The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the judges of the United States Court of Appeals are admonished to give their attention, for the court is now sitting. God save the United States and its Honorable Court.
Morning, everybody. Welcome to the Fourth Circuit. We have 4 cases on the docket this morning, and the first case is Carlton and Harris Chiropractic Inc. versus PDR Network. And Mr. O'Hara will be glad to hear from you.
Thank you. May it please the court. My name is Glenn Hara on behalf of the appellant, Carlton and Harris Chiropractic. Can the court hear me all right?
I can hear you.
Yes.
Great.
Yep.
Thank you. I'd like to focus on 2 issues today. The first is the important waiver/forfeiture issue that the court raised in its briefing order, issue number 7. And the second is why the FCC's 2006 interpretation that a fax offering free goods or services is an advertisement is a reasonable one, and why the district court erred in dismissing our case. On waiver and forfeiture, PDR admits that it did not raise issues 2 through 5 in the district court or in this court in the first appeal. That encompasses the legislative versus interpretative distinction, the Administrative Procedures Act, the due process arguments, and the separation of powers argument. As the court anticipated in its briefing order, those issues are forfeited. PDR has never explained why it couldn't have raised those issues the first time around. And it clearly could have. Those issues, those arguments have been made in other cases. Under this court's precedence, primarily omni advertising, the court held that where an argument could have been raised in an initial appeal, it is inappropriate to consider that argument on a second appeal following remand from the Supreme Court, even when the first decision is vacated.
Mr. Hara, refresh my recollection, did this issue of waiver or forfeiture come up during the Supreme Court arguments?
Yes, I argued that the petition or that the appeal should be dismissed as improvidently granted, but the court didn't rule on that one way or another. When it remanded, notably, the Supreme Court said this court could decide any other issues that may arise during the course of this appeal. And one of the issues that has arisen in the course of this appeal is whether all these arguments are forfeited. And we say, importantly, they're not just forfeited. PDR didn't just fail to raise these arguments. They affirmatively waived any challenge to the validity of the FCC rule in the first appeal. In the district court, in the reply in support of the motion to dismiss, at pages 80 to 81 of the joint appendix, PDR expressly disclaimed that it was making any challenge to the validity of the rule. It conceded that that would violate the Hobbs Act.
In a different world, I'd perhaps be a little bit more confident about the forfeiture and waiver issue, but having been reversed already once by the Supreme Court, I think my sense is that it would be a bit odd to effectively thumb our nose at the Supreme Court's direction that we consider, at least by implication, suggestion that we consider these issues on the merits, notwithstanding the question of forfeiture and waiver.
Judge Diaz, I understand that. If you read it closely, though, the Supreme Court didn't reverse this court on the merits. What it said was, we can't decide the question presented without answers to these 2 preliminary questions. So we just can't reach a decision. And they vacated and remanded on those 2 questions and any other issue that may arise during the course of the appeal. The court did
Mr.
not
Hara, let me
order
ask you this. Does it, from your point of view, I suppose if we were to decide those issues on the merits, that you have arguments obviously on the merits, so why don't you get to that and let's talk about that.
Sure. So this court held, so if the court holds that, the issues aren't waived or forfeited, then the question is, what level of deference do you give to the FCC interpretation? And we already litigated that question in the first appeal, whether the rule is reasonable or not. The court concluded that the FCC's interpretation was a reasonable one.
But in the first appeal, did you concede that it was an interpretive rule that didn't have the force and effect of law?
No, the issue was never raised in the first.
Okay, but now you concede, don't you, that it's an interpretive rule, or do you not?
It is an interpretive rule, yes.
Okay, so does an interpretive rule have the force and effect of law?
It is subject to either Chevron deference or Skidmore deference, depending on what level, what standard the court applies. We say
Well,
Chevron
okay.
deference, that's what's.
So, and what support is there for Chevron deference being applied to an interpretive rule?
I would cite the Circuit Court of Appeals decisions that have reviewed FCC interpretations in Hobbs Act appeals, like the DC Circus decision in ACA International, 885 Fed Third 687. It applied Chevron deference in determining whether the FCC's interpretation of the term automatic telephone dialing system was reasonable or not.
Do you have any Fourth Circuit cases?
I don't believe I do have a Fourth Circuit case involving an interpretive rule and, by the FCC. Yes.
I just want to make sure I understand your argument. So you agree that this is an interpretive rule. And so do you agree that because it's an interpretive rule, the Hobbs Act sort of applies differently and doesn't bind a district court to that interpretation? Or do you think that even though it's an interpretive rule, it's still fully covered by the Hobbs Act like any other rule?
Your Honor, we made the latter argument in our opening brief. Then the government took the position in its amicus that this is a non-binding interpretive rule. And so we were faced with the choice, are we going to argue that the district court is required to follow something that is non-binding? And we decided in our reply brief that we weren't going to do that. We were going to
Okay,
stick
so
right
you
to
are, so
the
you are
Chevron.
basically, just so I understand, because I feel like we have so much to decide in this case, but less so if you're conceding. So you are conceding this is an interpretive rule, and because it is only an interpretive rule, whether or not it is a final order under the Hobbs Act, so maybe you could still bring a pre-enforcement action, this rule does not bind the district court in this case. The district court is free to sort of assess the rule as though the Hobbs Act did not exist. That is your position.
If the issue is not waived or forfeited, yes.
Got it.
That's
Okay.
our position.
Okay.
So tell me how you get to Chevron deference under that scenario.
Well, as Judge Thacker analyzed it in her dissent in the first case, it's subject to Chevron deference because the FCC has expressed statutory power to implement the Telephone Consumer Protection Act. And part of that power includes interpreting the statute's terms. It has it's issued many interpretations of the TCP over the years, and those are always accorded Chevron deference.
I think a lot has changed since that dissent. That dissent wasn't addressing what was viewed as an interpretive rule at the time.
Well, I mean, Chevron has to do with
I still
interpretation.
think Judge Thacker's dissent is correct, but under Skidmore deference.
Sure, I understand. And, one important aspect of the dissent in the initial appeal is the finding that the statute itself is ambiguous. And that's important in the Chevron analysis because that leads you to see what the agency, with responsibility for administering the statute says about it. And I want to touch on PDR's argument. They say the statutory definition of advertisement unambiguously requires that you should read it as an advertisement is something that advertises the commercial availability or the commercial quality of something. And as we argued in our reply brief, that leads to a redundancy because the commercial quality just means the quality of being commercially available. It would be totally redundant to say commercial availability or commercial quality. The word quality in the statute, as the FCC read it in paragraph 52 of the 2006 order, refers to the qualities of the thing. In this case, that the PDR is trustworthy, it's new, it's improved, it will help you manage your digital workforce. Those are the qualities of the free good or service that's being advertised. It's not that it has to be commercially available. That's too narrow an interpretation of the statutory term advertisement. Yes, Your Honor.
Counsel, assuming now we're just looking at this regulation the way we ordinarily would, no Hobbs Act, under either, I guess, Chevron or Skidmore, although it seems like it would be Skidmore to me. But PDR's main argument seems to be that we shouldn't find this regulation either reasonable or persuasive under Skidmore because it doesn't explain why it treats faxes differently than phone calls in considering what counts as an unsolicited advertisement. What's your response to that?
Yeah, my response is the FCC has made this. Can you hear me, Your Honor?
Mm-hmm.
Okay, my screen just froze. The FCC has made clear several times that it treats faxes and telephone calls differently. They're governed by different parts of the statute, and there are different rulings and interpretations on those different provisions. We cited the FCC's amicus brief in the Palm Beach Golf versus Sarah's case in the 11th Circuit. But you know, maybe it's a little esoteric, but we TCPA practitioners are always careful to distinguish the TCPA call rulings from the TCPA fax rulings because they're like different worlds. So,
well, I mean, I do understand that, but here it's just the exact same two words, right? Unsolicited, now I can't remember what they are, unsolicited advertisement, I think?
correct.
And I do understand that the larger regulatory apparatus looks different in those two contexts, but is it your position that those two words mean something different when applied to a telephone call than when applied to a fax? And that's just so obvious there would have been no need for the agency to address it in issuing this interpretive rule.
It is possible for that same term to mean two different things with respect to calls and faxes, but I don't think you necessarily have to reach that conclusion here. In the 2003 ruling that PDR cites, the FCC was exempting certain calls from the auto dialer provisions, so it had policy reasons for doing what it was doing that were motivating it. Similarly, it had policy reasons in the 2006 order because it realized that faxes offering free goods or services are so problematic and they're so often a pretext to either future advertising or part of an overall marketing campaign that they should be covered by the definition of advertisement. And I want to stress that doesn't necessarily make them unlawful. You can send unsolicited advertisements if you follow the rules in section B1C. You send them to people with whom you have an established business relationship, you obtain the fax number in a permissible way, and you use a compliant opt-out. The district court said that we were advocating a blanket ban on faxes offering free goods or services, and that's not the case. You just have to follow the rules. And a sophisticated entity like PDR should be able to do that.
Mr. Hare, one of the issues that came up during the initial round of litigation in our court was the question of how, because we had concluded that it was a legislative rule, we didn't really have any cause to determine whether or not the interpretation of the statute was reasonable. Now, apparently we do, given that you can see that it's an interpretive rule. And so the question is, what limit, if any, applies to the FCC's interpretation? So, for example, the question of charities and the delivering facsimiles by charitable organizations, it would seem that literally the FCC's blanket ban on unsolicited advertisements would apply with equal force to that group of entities. Is that your view of it?
Yeah, I believe under a per se rule that it doesn't matter if the sender is a charity or if the sender is a for-profit business. Now, it's different under the majority's decision, the Second Circuit decision in Physicians Health Source versus Behringer. There, the fact that the defendant was a for-profit entity was important to the court's analysis. The Second Circuit there, the majority held, there's a rebuttable presumption at the pleading stage that if the fax relates to the for-profit sender's business activities, that they're doing it for advertising purposes, that there's either further advertising at the free seminar or in the free publication in this case, or that it's just part of an overall marketing campaign.
Excuse me, Mr. Hare, do we need to even go there, I guess? I mean, I thought your theory of this case was that PDR, if not directly, at least indirectly, is engaged in commercial solicitation and advertisement because it hopes through the delivery of what is a free reference to have medical doctors and hospitals ultimately purchase and prescribe the drugs that are described in that reference. So isn't that the question, whether or not that FCC interpretive rule is applied to these facts, whether that's a reasonable fit in these circumstances?
Yes, that is definitely part of it. Because PDR has some relationship. We've had no discovery in this case, of course, but PDR is paid by the drug companies to distribute the physician's desk reference. I think we're entitled to know what the details of that arrangement are. Is it based upon the number of copies of the ebook that they distribute? There's also, PDR made it clear that it sells all kinds of other healthcare products and services. The materials that PDR submitted in support of its motion to dismiss sought judicial notice of documents describing PDR's, large business. But we don't understand all the details of it. And I would like to see, before my client's case is dismissed for failure to state a claim with prejudice and without leave to amend even once, I think we're entitled to see the 2014 ebook. No one has ever seen it. The district court hasn't seen it. This court hasn't seen it. We haven't seen it. I was able to find the first couple of pages of the 2015 ebook, the next year, on the internet, but I couldn't access the whole thing. But it contains an advertisement for the PDR network, for the PDR pharmacy discount card. And we sought leave in the district court to amend the complaint to allege that the fax was a pretext to further advertising contained in the 2014 ebook, including the PDR pharmacy card or other services that PDR offers. And the district court ignored us. It didn't rule on our request to amend. It just dismissed the case with prejudice.
All right,
So,
Mr. Hara, you're over your time, but you've got some time saved for rebuttal, and we'll hear from Mr. Stern.
Thank you. I'm sorry, Mr. Dean, I have audio, but my video is frozen. Is there anything I can do about that? You know what? Should I do that? My audio is working, and I can complete the argument this way. I'm hesitant to take a chance on that. But you can see me.
We can see you yeah.
Okay.
And more importantly, we can hear you as well, so it's
Great.
fine.
Okay, we'll stick with the status quo.
Okay, thank you, Mr. Hara. Mr. Stern?
Thank you.
Thank you, Your Honor. May it please the court. If the court's aware, the United States participated as amicus in the Supreme Court to urge the position, which is still our position, that there should be no review in a district court private party proceeding of a Hobbs Act order. Now, at this point, the Supreme Court, while it
Oh, he's frozen. Mike?
reject that position,
Mr.
remanded.
Stern, can you hold on for a second? You froze up. We didn't
Of course.
catch. Mike, are you there?
Oh, no, I used the link that we used when I discussed.
Oh, that's okay. We're working our way through this.
No, it's entirely my fault. I apologize.
Go ahead.
At
Mr.
any
Chair.
rate, okay, um, we're obviously at this point, what we're addressing are the court's admonition that to decide the question of reviewability, it wanted to look at two considerations that had, in its view, not been fully addressed up to that point. And the point I think that we're trying to sort of like address in our brief as amicus is that while we continue to think that the position that we articulated in the Supreme Court is the correct one, that there are reasons, as the Supreme Court's decision suggests, why there might be a break point between interpretive rules that are not subject to the same notice and comment procedures as legislative rules, which don't get the same degree of deference and have a different legal impact. And with those points in mind, and sort of taking that sort of as the assumption here, what we've indicated is that we agree with plaintiffs that this is an interpretive, not a legislative rule, and that unlike a legislative rule, it did not go through the same kinds of notice and comment procedures, so that while people about this rule, it wasn't put on notice in the same way. And the sort of, as the court's aware, when the FCC solicited comments on aspects of its rule in 2003, it didn't, in the way it would in a notice and comment procedure, lay out exactly what its concerns were. Sorry.
So where does that leave us then? The government has conceded that this is an interpretive rule that didn't go through the full notice and comment procedures. So was the district court required to follow it or not, based on the government's viewpoint?
Well, again, the position, if the position that we articulated in the Supreme Court were ultimately to be upheld by the Supreme Court, then the district court erred in undertaking review. However, what we understand the Supreme Court's decision to be saying—
Wait, I didn't hear an answer to my question. In the government's view, was the district court required to follow this interpretive rule or not?
The answer is yes.
Okay, why?
That's for all the reasons that we articulated in the Supreme Court.
Well, I can't sort out all of your reasons because they seem to be saying two different things at different times in different courts.
Well, I apologize. I just want to make clear that what we've addressed here are not all of the questions that were presented to the Supreme Court. We understand this to be what the Supreme Court did was not to ask the question before it to be totally revisited. The court wanted to know a couple of things that it thought would be possibly crucial to its decision. Didn't indicate for sure, but it certainly sent that strong message. And we take—
Okay. So what I would like to know is why the government is of the view that the district court is required to follow an interpretive rule. Just whatever your best argument is or best case, something.
Okay, Your Honor, I mean, I didn't really sort of come to fully sort of or deal with all of those issues which were dealt with in the Supreme Court, but basically it boils down to a sort of both the statutory language talks about orders. It does not distinguish between legislative and interpretive rules, and several courts of appeals have found interpretive rules as well as legislative rules to preclude review in district court action, and there are historically very good reasons for all of this. But the point that we're trying to make on this limited remand is that the Supreme Court was apparently sending a strong message that perhaps a rule should differ when, depending on whether it is legislative or whether it is interpretive, and depending on the kind of notice that is given. And notice in this instance is very much linked, just by the way, to whether it is legislative or interpretive, because a legislative rule must go through notice and comment, very elaborate procedures, which have always been thought to provide adequate notice to concerned parties. So taking that cue from the Supreme Court, we've suggested that indeed you can, while we don't think that the court should make that distinction, we agree that that is like one that can be made. We can understand why the Supreme Court might be thinking that that would be an appropriate breakpoint. And that's one of the points we were trying to make in our brief. And the other, we're simply trying to sort of express our understanding that this regulation is interpretive and acknowledging did not go through the same kind of procedures as a notice and comment rule would. So that if the breakpoint is indeed that which the Supreme Court appeared to be suggesting, then the situation would be that, yes, a court could review it, and since it's an interpretive rule, it would be according, Skidmore, deference, not Chevron deference. And so that's the we're sort of making a fairly modest point here, but we also think it's an extremely important point, because I want to rehearse all the reasons that we think that the Hobbs Act, the problems that are created when Hobbs Act orders are subject to review in private party litigation. This may
Judge
not be...
Diaz, that answered my question, at least.
Okay. Mr. Stern, you're...
I'm sorry, Your Honor, if I'm over my time, I apologize.
Yeah. Thank you very much.
That was my fault.
No, that's fine. Thank you, Mrs. Stern. All right, we'll hear from the appellee, Mr. Akowa. I'm sorry if I didn't pronounce that correctly, but you'll correct me, please.
No, that was actually perfect, and you're just about the only person who's ever pronounced my name correctly the first time. So thank you for that, Your Honor.
Yes, sir.
I am a little surprised that the government is having difficulty answering these basic administrative law questions the Supreme Court held in Chatterton versus Marshall. Yes, Judge Harris.
Well, I think part of the problem for the government and for us is that the case we are seeing today bears no familiarity at all, no resemblance at all to the first case we saw. And the government is right. Like, in order to fill out what's going on, we actually have to read Supreme Court briefs that make arguments that we have never seen before. And so I think that's why the government is having trouble. It's got a merits brief in the Supreme Court that is responsive to arguments that were never even hinted at when this case was before us. And to fully understand the government's position, we have to go back and read that brief too, which is full of stuff we've never looked at before. And so, I'm just finding this sort of frustrating. On appeal, you said expressly the Hobbs Act would bar a challenge to the validity of the 2006 rule in this proceeding. Now you're taking the opposite position with a bunch of arguments that we have never seen before. Why is this okay? We don't usually let people take inconsistent positions in the same case and bring an entirely new case on a second appeal. So how come this is all right? It's very difficult.
A couple of things. One, we always took the position that the district court was correct, did not err in reasoning that it was not bound by the FCC's rule. They could look to the statute rather than the FCC's explanation. In fact, going back to the argument that Mr. Rosenthal presented last time, Judge Harris, you asked him a series of questions about, well, is your argument only about the possibility that the the rule can be harmonized with the statute, or are you also arguing that the statute, that the district court could look to the statute? And he clarified, just as we said at page 14 of our appellee brief then, we're taking the position that the district court was entitled to look to the statute, ask what the statute means. So yes, was there some back and forth about what the validity? Our position today continues to be that the district court does not act on the validity of what an agency does, even in a legislative rule context, when it simply acts on a private party dispute, because it doesn't issue.
So you're saying your positions have been consistent all along. That's your argument?
My position is, I think our brief could have been way clearer, but ultimately we took the position that the district court was entitled to look straight to the statute. Then you also have the mandate rule issue that Judge Diaz raised, that the Supreme Court said, please look at this interpretive rule, legislative rule issue, please look at the 703 issue, whether they had a prior adequate opportunity to review, as well as any other issues that may arise. So I think the direction, frankly, is to look at these two issues and not come back to the Hobbs Act preclusion question. Yes, Your Honor.
So I really have been wrestling this, and I just want to make sure. So your ultimate position is waived or not, forfeited or not, the Supreme Court said to do this, so do it. It's totally legit position. I just want to make sure.
Yes, it's mandate rule, but it's also that these questions go to subject matter jurisdiction, and so are not. I mean, that's exactly how the court understood it. We're talking about a statute that talks about exclusive jurisdiction and then the implicit preclusive effect.
I know. I'm sorry. I will get off this in a minute. I think that's not quite right. I mean, the district court has jurisdiction over this action. There's no question about that. The question is whether PDR waived a defense. Don't apply this rule because it's inconsistent with the statute, over which the district court might or might not have jurisdiction. But we wouldn't have to reach that if we thought defendant didn't raise that defense in the right place.
Again, but I think the question on review is whether the district court exceeded its jurisdiction by considering the question of what the statute means.
Right.
And
if we wanted to address that question, right. But I'm saying we might not have, if the entire issue has been waived, ordinarily and apart from the mandate, we just wouldn't reach that question.
And then that comes back to where I started.
Okay.
What we said in our appellee brief is the district court did not err when it looked to the statute to decide what the controlling rule is. So that's been in the case all along. The language about the validity and such, I think that there's been a lot of back and forth about exactly what that means, but we absolutely raised the question and defended the district court's judgment on the ground that the district court had the authority, notwithstanding the Hobbs Act, to ask what the statute means. As to whether an interpretive rule is binding, Batterton versus Marshall, Perez versus mortgage bankers make clear that an interpretive rule is not binding on a court, it's not binding on an agency, and it's not binding on private parties. So I think that is actually quite straightforward. And as to Chevron, the court's decision, the Supreme Court's decision.
I'm sorry. So I know there's all that case law saying an interpretive rule is not binding, but that all arises under the APA. Under the APA, do we treat it as binding or not, or do we give it Chevron deference or not? But I feel like the hard question in this case is we also have a statutory mandate under the Hobbs Act. And so I don't think it's enough to say that absent the Hobbs Act, this rule would not be given binding effect. I totally agree. Wouldn't get Chevron deference. It wouldn't be binding just under the APA by itself. That's not how we would treat it. But the question is what difference it makes that Congress has passed this other statute saying that for some agencies, any final order is going to be treated as binding by the district court.
Right. And what the Supreme Court has said is that it is the APA that defines what force and effect is given to an agency action, and the Hobbs Act defines the mode of review. And so I think when, again, coming back to did it bind the district court, the APA is answering the question. The other way to look at it is the Hobbs Act is providing a way for people to go and bring lawsuits against the United States government. Why would you bring a lawsuit against the United States government? Because they said something that maybe you think is wrong, but doesn't affect your legal rights and interests, doesn't control your conduct or anyone else's, and may not be refined in any way. You have the ripeness and justiciability and standing issues that all come into play because of that basic question of, well, why go sue now over something that doesn't even bind the agency? The agency can the next day take an inconsistent position so long as it explains it. So there's really no reason for people to go running to the courthouse over non-binding statements of, here's what the agency thinks. I think part of what the government is concerned about is that there are heavily regulated entity settings where everyone in the room is reading the Federal Register every single day. They're watching like a hawk everything that the agency does. Yes, Judge Diaz.
So in the amicus brief that was filed, I recall a footnote that indicated litigation with similar issues raised in a different case. And I get the point that you're making that in the abstract, perhaps the order wasn't ripe, it wasn't appropriate for you to challenge it when it was first being addressed by the FCC. But at the point that your client was sued, wouldn't it have been appropriate at that point to seek an interpretation from the FCC as to whether or not your client's actions were governed by the rule?
We could have done that. We could have gone and opened another front in essentially a side litigation. But the question here is whether our decision not to do that, it had the effect of stripping the district court of jurisdiction to ask the question of what the statute means. And the answer to that is no. That kind of brings us into the 703 territory is principally where we discussed this point. But what Section 703 says is we're preserving judicial review and civil and criminal enforcement actions unless given a prior adequate and exclusive opportunity and an opportunity arising after.
You think it's an either-or proposition? They're not mutually exclusive, the opportunity to litigate in front of the FCC and/or the district court?
They're not mutually exclusive, Your Honor. What the Hobbs Act makes exclusive is the opportunity to seek pre-enforcement review. Once there's an enforcement action, functional music says this, and every court of appeals to consider the question has said, once there's an enforcement action, then the opportunity to defend oneself in the enforcement action by re-raising the statutory question re-arises. And so we're just asking for an application of that principle, which no one disputes applies if the government brings the enforcement action to the private enforcement action setting. If I may turn to the merits.
I'm sorry, can I just ask a
Sure.
clarifying question when you said no?
Sure.
Are there courts of appeals that have held that the Hobbs Act doesn't apply to interpretive rules? Is that what you're saying? That's well understood out there?
So here, what's well understood is that when legislative, interpretive, otherwise, when a government agency, including a Hobbs Act agency, brings an enforcement action against a private party,
I'm sorry. So not in private, but in the context of private actions like this one, are there any court of appeals cases saying that the Hobbs Act would not apply to an interpretive rule? It would not, that under the Hobbs Act, the district court would not be bound to follow the interpretive rule? I'm trying to be clear. We would be the first court of appeals to say that, right?
I think only one court of appeals has squared up to this question.
Right. So we would be the first court of appeals to say that.
You'd be the first court of appeals to apply the administrative rule standard that an interpretive rule isn't binding in the Hobbs Act context.
This is just a yes or no question. I want to make sure I haven't missed any cases. There are no cases, no court of appeals cases doing that, right?
I'm not aware of any court of appeals case that asks the Hobbs Act question specifically and says not binding. That's correct.
Okay.
If I may turn to the merits, Judge Diaz, you asked a question that I think is absolutely pivotal, and that is whether plaintiffs' proposed construction would apply to charities and nonprofits by saying that commercial doesn't apply to quality. And the answer is yes, it would apply. The Supreme Court's decision in Clark versus Martinez makes clear that when a court interprets a unitary statutory phrase, it gives it meaning, that meaning necessarily applies in all of the contexts to which that phrase applies. And so and the FCC has said, and said right in its 2006 order in paragraph 43, the statute gives us no ability to distinguish between for-profits and nonprofits in the facts context. And actually that's important. Not only could the agency not fix it, but Congress, I don't think, could have said for-profits get one rule, nonprofits get another rule. Under the Supreme Court's recent decision affirming this court's decision in Barr versus American Association of Political Consultants, the Congress's decision to say, actually, people who are collecting government debt aren't subject to the TCPA was struck down under the First Amendment because it created a speaker-based constraint on speech and distinguishes between different kind of people saying the same kind of thing. And that very constitutional problem would arise. The other problem that would arise is that the court would then be having the constraint run to non-commercial speech. So you have a whole welter of policy problems, and yes, Judge Diaz.
Just so I understand this, your line of argument here, are you saying that the statute itself is problematic because it might implicate entities charitable entities as an example, or that the statute as interpreted by the FCC is problematic because it sweeps up these larger groups of entities that Congress could not have intended to be implicated by the act?
I would say a treatment of the statute, focusing first on plaintiffs' construction. I think the plaintiffs and the government's constructions are somewhat different. Plaintiffs' proposed construction is that the statute should be read to mean that unsolicited advertisement means material advertising the commercial availability or quality, but quality not modified by commercial. So if it either advertises the commercial availability, and as to commercial availability, plaintiffs' counsel agrees with us that means the commercial exchange involving the purchase or sale of property, goods, or services. That's in his supplemental reply. He says, but commercial doesn't modify quality, such that material advertising the quality, regardless of any commercial connection, would be an unsolicited advertisement. I'm saying that construction, which takes out the commercial nexus, 100% would run to nonprofit entities.
Yeah, although I'm not
Yes.
sure why, I think I asked Mr. Harrer this, I'm not sure why he has to go that far, because it would seem, of course, he's indicating that he still doesn't understand the full scope of your client's activities, but if in fact, at a minimum, the PDR reference is, even if free, is intended to entice or encourage doctors, hospitals, medical professionals to obtain, purchase, and then prescribe drugs to third parties, i.e. consumers, why wouldn't an FCC regulation that bars that kind of activity fall well within the ambit of the statute?
So I think here it's important to focus on what was pleaded and what was not pleaded. What was pleaded was that the fax itself offering a free copy of the 68th
Sure, I
edition
understand
of the
that, but
PDR.
I suppose I get that. But why wouldn't an easy fix be, as Mr. Harris suggested, that he be allowed an opportunity to amend the complaint to plead now this new theory of liability?
No, Your Honor, because he never moved for leave to amend. And yes, Judge Harris.
But I know that he asked for leave to amend in a motion, right, in his
Your Honor.
response to, but if I'm remembering right, this is a long time ago, shoot. But I thought that your client moved for judicial notice of certain facts also in a motion. And I'm sorry, also in a brief and not in a separate motion. And the
No, Your
district
Honor.
court granted that, right?
My client made
it's-
a separate motion. It's docket entry 20 on the district court for a judicial notice of the one-page printout of the website. So it's absolutely clear that we made the motion. It's clear the scope of what the district court granted.
But isn't our law pretty clear that if you state with particularity how you want to amend your pleadings, whatever you have captioned that document, the district court is at least supposed to rule on it?
No, Your Honor. ACA versus Financial Guarantee Corporation from this court just last year in 2019 involved a case where a party had made 6 separate requests in briefs to make an amendment to their pleading. And what the court said was that the parties asking that came up on appeal and said, actually, we should have gotten a chance to leave. They conceded, this court has held over and over again, that a district court, and I'm quoting here, this is 917 F 3rd 206 at page 218. They concede that this court has held that a district court does not abuse its discretion by denying contingent requests to amend in the legal memoranda made in lieu of a motion to amend. They argue, however, that this court should follow other circuits which, according to their interpretation, find that requests made in opposition memoranda constitute a proper motion to amend. We declined to do so. And the court was echoing a whole line of cases going back at least 10 years in this court that have made clear that a motion to amend is an optional, and a district court that declines to address a motion that's not properly made as a motion that doesn't set out, here's our amended complaint, the district court does not abuse its discretion. So I think Mr. Hare is right in his supplemental reply in saying the question is, did the district court abuse its discretion? But he's wrong about the answer because this court's precedents made clear, no motion, no abuse of discretion. So the only theory that's on the table in this case was the theory that the facts itself, because there are essentially no other facts pleaded, no other factual allegations pleaded in the complaint, that the facts itself was the advertisement. There's no pretext theory. And in fact, the plaintiff's opposition brief to the opposition to the motion to dismiss at page 11 says, I did not plead an overall marketing campaign theory. In his original appellant's brief to this court, I did not plead an overall marketing campaign theory. What he said, I ought to get a chance to plead that theory. But again, the court's precedents make clear that that's not correct. The district court did not abuse its discretion in denying that opportunity. And so really the only question is whether an offer of, again, societally useful commercial or societally useful information of a technical nature, coming back to the exhibit that was attached to the complaint, the same trusted FDA full prescribing information, whether a compendium of that, the 68th edition of it, offered in a new format, a new convenient digital format, whether that is an advertisement, and the answer is a district court held, and as so many other courts across the country have held, is no. And one place that I'd like the court to focus is Judge Mehta's decision in the drug reform coordination decision of the District of DC, where he addressed a kind of similar setting. There was a free fax offering inclusion at no cost in a directory, and Judge Mehta said, relying on this very same FCC materials that we provided in our 28J last week, he looked at those, applying the 2006 rule, and said, if it's just a fax that just offers something for free, not an advertisement. What happened in that case that led to the motion to dismiss being denied was that there was a pleading that there were subsequent communications. In those subsequent communications, there were offers of sales. And Judge Mehta said, take those together. It's a free fax, not an advertisement. But quickly followed on, as the allegation is, by offers to sell materials, then you have an advertisement. I think the court can accept that theory, but say, look, it's not nothing more than the first fax, free, is pleaded here, and that's not an advertisement because it doesn't promote a commercial exchange. Yes, Judge Diaz.
You're a little bit over your time, counsel, so I need you to wrap it up so that we can allow Mr. Harrison time for rebuttal.
Sure, and yeah, I'm happy to rest unless the court has any further questions.
Any of my colleagues have further questions? All right, thank you very much. Mr. Harry, you've got some time for rebuttal. Go ahead.
Thank you, Judge Diaz. On the question of requesting leave to amend the complaint in the response to the motion to dismiss, we cited a recent case from this court at page 21 through 22 of our reply brief Matrix Capital Management versus Bearing Point, the court there held that a, quote, outright refusal to grant leave to amend requested in a response to the motion to dismiss without stating, quote, any justifying reason was an abuse of discretion. And that's exactly what the district court did here. It just ignored our request to allege a pretext theory. I'd like to address the functional music case. This keeps coming up in this case. It's a DC Circuit case, but counsel for PDR cites it for the proposition that when the agency brings an enforcement action against a defendant, they can challenge the validity of the agency's interpretation. But that's not what happened in that case at all. What happened in functional music was years after an order was issued, the defendant brought a petition to deem that interpretation invalid, long after the Hobbs Act 60-day window for a direct appeal. I mean, years later, 7 years later, something like that. And it went up to the DC Circuit. The petition was denied. The FCC said the order was okay. Went up to the DC Circuit, and the DC Circuit said, you can bring this Hobbs Act challenge years after the 60-day jurisdictional window has closed, because what you're challenging is the agency's statutory authority to issue this rule. And therefore, you're challenging is ultra vires. And so you can bring that at any time. You can always argue that the agency lacked authority to issue a rule. Similarly here, on the prior adequate exclusive opportunity question, PDR could have participated in the rulemaking in 2006, obviously. Fine, if it's unfair to hold them to that, they could have petitioned at the most relevant time would have been before they sent the faxes at issue in this case, right? Before you send thousands, God knows how many thousands of faxes, you hire a lawyer and they say, you know what, there are laws about sending faxes in the United States. Let's look into this. You would find the 2006 order. Any lawyer would find the 2006 order. And when that lawyer reads paragraph 52 that says offers of free goods or services, especially free publications, are advertisements, what's that lawyer going to do? They're going to say, either don't do what you're contemplating doing, or go petition the FCC to clarify this rule, or rescind it if you think it's wrong. What you do not do is go ahead and send your advertisements without doing anything about it. PDR only focuses on 2006, and they argue that that's the relevant time period. But they could have petitioned under functional music. They could have petitioned the FCC at any time before it sent its faxes and before it got into trouble. It just was careless. It just didn't do what it was supposed to do.
Well, but Mr. Harber, your colleague says that it's not an either-or proposition. That having failed to do one doesn't mean that you are then barred from actually litigating the issue in district court.
I understand that. It's just on that limited. Was there a prior adequate exclusive opportunity? They clearly had one, and that's the only point I was trying to make. Let's see. The drug reform case, of course, the motion to dismiss was denied. We cite numerous cases where the motion to dismiss is denied at the pleading stage. And, you know, this court's initial decision was correct. The FCC's 2006 rule is a per se rule. The only other court of appeals to have decided a free goods or services fax in a TCPA action is Physicians Health Source versus Behringer. And of course, this court sided with Judge LaValle's concurring opinion that it's a per se rule. The majority found that it's a rebuttable presumption at the pleading stage. So our alternative argument that we've raised in our briefs and our fallback is, you know, if all else fails, the court should join the majority in Physicians Health Source versus Behringer. That would be another way to resolve the case. Another easy way to resolve it would be to reverse the district court's denial of our motion to amend as an abuse of discretion and remand on that. But in any case, the district court's dismissal of this case for failure to state a claim should be reversed. Thank you.
Thank you, Judge Stacker. Judge Harris, do you have any additional questions?
No.
Thank you, Mr. Harris. I want to thank counsel for their arguments here this morning. The case has been submitted, and the court will stand in recess awaiting the second case. Typically, we would come down from the bench and greet you personally, but obviously in this age of COVID, that is not possible. But please know that we're very pleased that you were able to join us today, and thank you again because we would not be able to do the work that we do without the able assistance of lawyers such as yourselves. So again, on behalf of the court, my colleagues, thank you very much. Court stands in recess.
This time the court will take a brief recess. Of the United States Court of Appeals for the Fourth Circuit.
sorry. I don't know that you heard any of what I just said a few moments ago because I either went on mute by accident or just incompetence. So I'll try that again. We're ready to hear argument in our second case, United States versus McCoy. Mr. Attias, whenever you're ready.
Good morning, Your Honors, and may it please the Court. The First Step Act changed the compassionate release statute in one way relevant to this appeal. Prior to the First Step Act, only the BOP could move for compassionate release on an inmate's behalf. Now, after the First Step Act, inmates may personally file motions for compassionate release in the district court. This change, however, was entirely procedural in nature. Nowhere in the First Step Act did Congress grant district courts the substantive authority to define their own criteria for compassionate release. The district court, however, concluded that after the First Step Act, subdivision D of the relevant policy statement conflicted with 3582C1A, and that therefore it could usurp the BOP's role under that subdivision and create its own criteria for compassionate release. The court went further, though. Not only did the district court hold that it could define its own criteria for compassionate release, it further held that it could implement explicitly non-retroactive statutory amendments via compassionate release. Either of these conclusions is sufficient to warrant reversal. I'd like to start with the district court's conclusion. Yes, Judge Harris.
Sorry, on the first point, where the district courts held that the policy statement was inconsistent with the First Step Act, I have a sort of a threshold question. Before you even get to whether there is an inconsistency, the policy, it has to be an applicable policy statement. And I'm not understanding how this policy statement, 1B113, is applicable here, because by its terms, all it says is what happens when the Director of Bureau of Prisons files a motion. And it says, upon a motion from the Director of Bureau of Prisons, all of this stuff will follow. But there is no policy statement for what happens when a defendant files a motion. So how is this an applicable policy statement for purposes of that consistency requirement?
Judge Harris, the commission has to do two things to bring the policy statement up to speed with the statute. First, and I think this is a reference to the language you're referring to, it has to update the prefatory language of 1B1.13 to reflect that defendants may now also move for compassionate release.
Right.
And
at that point, we'll have an applicable policy statement, but right now we just don't.
Well, we concede that there are parts of the policy statement that are either in conflict or need to be updated, but none of that goes to subdivision D, which is the relevant provision in this case.
But why is this an applicable policy statement when it doesn't say anything about what happens when a defendant files a motion? By its terms, it begins, upon motion of the Director of the Bureau of Prisons under this statute, and then a bunch of very important stuff follows. But I just don't see how you would say when a defendant files a motion that this is applicable.
Well, after
by its terms, it doesn't cover it.
Well, I think that argument goes both ways, Judge Harris. I think if this is not the applicable policy statement, then there may be, you could equally argue that there would be no compassionate release because there's no criteria that the commission promulgated. But we have no problem saying, and courts throughout the country have had no problem using 1B1.13 on a daily basis to adjudicate compassionate release motions. They simply now know that under 3582C1A, inmates may also move on behalf of themselves, and that it's not just the BOP who can do that. But our main position here is...
I'm sorry, you guys. This is my last question. So you're suggesting if there's no applicable policy statement, there can be no compassionate release on a defendant's motion?
Well, that could be a consequence of...
Well, is that the government's position? Is that the government's position? That until the Sentencing Commission acts, there will be no compassionate release on a defendant's motion? Because I don't read 3582 that way, but tell me if you do.
Well, that's not our position in this case because we don't need to go that far. We have a policy statement which district courts have been able to navigate, notwithstanding the fact that the prefatory language of 1B113 needs to be updated, and as do application notes 4 and 5. But I think it's critical to realize that in all three instances, prefatory language and application notes 4 and 5, the operative language there is upon a motion or pursuant to a motion. And subdivision D is just different, and we know that immediately because the word there is a determination. And subdivision D doesn't require updating because it's just not in conflict with the statute. If you were to line the two of them up, you wouldn't find conflict. And so our position here is that the First Step Act brought about a procedural change and that it had no impact on the substantive criteria that courts can consider when ruling on a motion for compassionate release. And the district court disagreed and held that it had the statutory authority to define the contours of its own discretion, and that providing a role for the BOP in determining the existence of other reasons would play. Yes, Judge Thacker.
Under the First Step Act, the defendant can file his or her own motion if the BOP has already declined to file a request, correct?
Yes.
All right, then why would Congress intend that the BOP determine whether extraordinary and compelling circumstances exist when the BOP would have already done that based on the statute? They would have already declined. I mean, it doesn't make any sense. It's going back to Judge Harris's question that there's no applicable policy statement here.
Well, I don't think there's anything inherently unusual about a system which eliminates a procedural hurdle but keeps the substantive decision-making authority with regards to one criteria with the BOP, and that's subdivision D. Inmates may move freely under subdivisions A through C, and they do that every day in district court. But if the BOP denies a motion, that's where the First Step Act kicks in. They now can come to district court and litigate that issue.
And then the district court determines the extraordinary and compelling circumstances as the courts did here.
The district court determines whether the criteria of 1B1.13 are met. What the district court did here is read into
And what's
the
the
First
criteria of 1B1.13 as applicable to the First Step Act that we're talking about here?
1B1.13 application note 1 lists out 4 circumstances where extraordinary and compelling circumstances could exist. It could be family, medical, or health, or age-related criteria, and then there's subdivision D, which was not changed by the First Step Act, but which the district court viewed the First Step Act's procedural change to mean that it now had the substantive authority to create its own criteria for compassionate release. And we know that that was wrong because under 994A2C and subsection T, it's the Commission's job to promulgate the substantive criteria for compassionate release.
But the Commission hasn't done that job here yet because it hasn't changed the policy statement.
Well, the Commission doesn't need to change the policy statement.
Well, the Commission says it needs to change the policy statement. The Commission said it itself in its 2019 report that it needed to change the policy statement, or the policy statement to comply with the First Step Act.
That's right. The Commission said that it needs to change the policy statement to reflect the procedural fact, that inmates may now move on their own for compassionate release. It didn't say anything about the substantive criteria with regards to subdivision D. I think that's, yes, Judge Harris.
I mean, I'm just having a lot of trouble with this substance procedure distinction. Sort of at the front end of the statute, or at the front end of the policy statement, I should say, right now you have BOP as sort of a gatekeeper. BOP gets to decide whether you've satisfied any of these provisions. And at the back end, under the catch-all, you have Bureau of Prisons playing precisely the same gatekeeping role. If letting BOP make the decision is a matter of procedure at the front end, it's procedure at the back end. And if it's substance at the back end, I don't understand why it's not substantive at the front end, because then you're letting BOP decide whether A through C has been satisfied. Like, I just don't understand how BOP playing a gatekeeping role can be substantive in one context and procedural in another.
Your Honor,
It sounds all procedural to me.
After the First Step Act, the BOP still has the statutory ability to move on behalf of inmates. The First Step Act said that inmates now may move on behalf of themselves, but it didn't strike the BOP's ability to move on behalf of inmates. And so
Right,
if
and
the
I
BOP
agree, this
were,
policy statement continues to apply. It's not like it's defunct. It absolutely applies when Bureau of Prisons brings a motion.
I think that the BOP could bring a motion under subdivision D, and that's because it retains its statutory ability under 3582, even after the First Step Act, to do exactly that. I think any other reading of subdivision D that grants district courts the ability to promulgate their own criteria for compassionate release is always going to run into 994T, which tells us that it's the commission's job to do just that, and nothing about the First Step Act changed that. And so too with regards to 3582.
Am I invisible? I don't understand this.
Yes, Judge Thacker.
I've almost lost my question. I don't understand how, so you're saying that the Bureau of Prisons, under both the old and the new regime, has the ability to make the motion. I understand that. But then if, under the First Step Act, if the Bureau of Prisons declines to make the motion, the defendant can make the motion on his or her own at that point. Then who decides whether the criteria are met?
Then the district court decides whether the criteria of subdivisions A through C are met.
Wait, what about D?
Subdivision D is premised on a determination by the Bureau of Prisons. That
It
some
used
other
to be. So you're saying that the First Step Act changed nothing about subdivision D?
That's correct, and we know that, Your Honor.
It changed nothing about subdivision D. Then why does the Sentencing Commission annual report say that a newly constituted commission will need to amend the sentencing guidelines 1B1.13 to reflect the new authority for a defendant to file a motion for compassionate release?
Because that's exactly what it needs to do. It needs to reflect in the prefatory language of 1B1.13.
It needs to reflect that nothing has changed.
No, several things. One specific and very important thing has changed, and that's the fact that inmates may now move on their own, and that's a sea change, and the commission needs to reflect that. I think what the commission is alluding to.
And when the inmates move on their own, you're saying that it's still the authority of the Bureau of Prisons to determine whether the criteria has been met?
Well, an inmate couldn't move on their own in the subdivision capacity. Only the BOP could do that. And that's exactly why the BOP has retained its statutory ability to move under subdivision D and in the statute.
Okay.
And I think
I don't want to delay your argument anymore because I know you're over time, and I don't think you and I are going to come to an understanding.
Well, Your Honor,
Mr. Attias, you are over time, so I'm going to stop you. You've got some time left for rebuttal, and we're going to hear from your colleague, Mr. Mettinger.
Okay. Thank you, Your Honor. May it please the Court, Jason Mettinger for the United States. In our view, Your Honors, federal law simply does not permit the district court to do what it did here, so we do respectfully ask that this court would reverse. What I want to do is jump right into a question that was asked by Judge Harris, because I think it is an important one about is this or is this not the applicable policy statement. I'll say two things on that. First and foremost, I don't actually hear the defendant saying that it's not the applicable one, so I don't think that's an argument the defense is making. But the second thing I'll say is I think we all need to do our best to sort of ensure that as much of what Congress wanted this structure to be is kept in place. And so let's continue the thought experiment. 994T says that the Sentencing Commission shall determine what is and isn't extraordinary and compelling. And so they've listed examples, they've enumerated the application notes that we've all been discussing. And I don't think it's the best construction, given that Congress wants the commission to decide these issues, to just reach a construction that throws all of that structure out. And I think if you look at what is left of application notes, oh, yes, Judge Harris.
Well, what the district courts are saying is not we want to throw it out. They'll continue to treat it as advisory. It's not as though A through C disappears. They continue to rely on it, but it's not binding in the same way.
Right, and that runs precisely, Your Honor, I think, into the buzzsaw of the words in 3582C, which says it has to be consistent with. And that really is the heart of our argument.
Great, let's go to the words.
Thank you.
I've been thinking about the words a lot. So what it says is that it has to be consistent with applicable policy statements, plural, issued by the Sentencing Commission. So is it the government's position that any reduction has to be consistent with more than one policy statement?
The applicable policy statements, I think Your Honor's question is, there's a plural there? And is that what you're getting at, Your Honor?
It is what I'm getting at.
And I think our answer would be the applicable policy statement here, and
right, but
really
I guess
is
what I'm getting at is
1B1.13. Yes, Your Honor.
Right, and what I'm getting at is I think the only sensible way to read this language, you wouldn't need applicable and it wouldn't be plural. If it meant that a reduction has to be consistent with a policy statement issued by the Sentencing Commission, that's what it would say. Instead, it says it has to be consistent with applicable policy statements, plural. And I think the only sensible way to read it is the way courts have long read it, which is to mean if there are any applicable policy statements, plural, it has to be consistent. It can't be inconsistent with any applicable policy statement, whether it's 1, 2, or 3.
Right, and Your Honor, I guess my retort to that would be, and forgive me if I'm wrong on this, but I think I'm not. If you look at 3582C2, I think the language is exactly the same. And then we go to the Dillon case, which we rely, frankly, pretty heavily on, which interpreted 3582C2. And there the Supreme Court looked at just one policy statement, 1B1.10. And so I think perhaps what I would retort respectfully, Your Honor, is that we shouldn't read too much into the plural versus not plural. I think everybody agrees, and the defense, frankly, is not arguing this either. 1B1.13 is the whole shooting match here. That's the only policy statement that applies, and it shouldn't give us heartburn that there's only one. And so we have to be consistent with that policy statement. And here the district court was saying, I don't have to be. I can be inconsistent, and that's perfectly okay. And our view is that that violates the law. It violates 3582C1A. It also violates 994T. So that's really the heart of our argument, Your Honor. I'd also like to address a question, if I could, that Judge Thacker asked, and it was the question about, why would we allow a construct, or why would Congress, when they passed the First Step Act, allow a construct that allows BOP to either deny a motion or to not make one, and then to sort of have the district court, look at it again. And I think the answer lies in why the First Step Act changes were made that were made. And I think if you read some of the legislative history, which, again, we don't think we need to consult, but if you read it, I think the primary problem here was that there were instances where defendants fell under the criteria listed in application note A, B, and C, that BOP was actually not making the motion. And so we're still looking at the commission's pre-approved criteria, but we're just giving the defendant the ability to say, hey, the BOP missed this one. I really do have a terminal illness, or I really do have a caregiver that passed away, and that's important to me. District court find as a fact whether that exists. Judge Diaz.
But the one thing you don't focus on is the example of a prisoner who says, I really have extraordinary and compelling circumstances under subsection D. The BOP either didn't take action or denied the motion outright. In the former case, where the BOP doesn't take action, isn't there a vacuum there? I mean, what are courts supposed to do in that instance?
Well, I guess my response to be that district courts absolutely cannot fill that vacuum themselves. Let's say there is, and I'll take your point. Some defendants think that there are extraordinary, compelling circumstances that they have, but there's absolutely no provision that allows district courts to sua sponte usurp that role. In fact, Congress said district courts, you cannot. This is the Sentencing Commission's regime. Yes, Judge
okay,
Harris, I
sorry,
see you.
I don't know which way to move, so my hand's in the thing.
Yes, Your Honor, I see you there.
So your understanding is that the Sentencing Commission can decide, look, there needs to be a catch-all provision. We can't sort of lay out all of the possible things that might qualify as extraordinary and compelling. There has to be a catch-all provision. When it comes to defining what counts under the catch-all, it's permissible for the commission to delegate that responsibility to the Bureau of Prisons, but it would be a violation of federal law to delegate that responsibility to the courts, notwithstanding that the whole point of the First Step Act is to get the Bureau of Prisons out of a gatekeeping role and give more room to the courts. That's how you understand the lay of the land?
So I think generally yes, but a couple points of clarification, Your Honor. First, I don't think it's correct to say that Congress wanted to get BOP completely out of the game. And I take your point. You used the word gatekeeping role, and I think that that change was made. But again, we're not trying to shunt the BOP completely out the door here. And the reason for that, I think, the real reason, BOP is closer to the ground. It understands unique circumstances that are going on in their prison populations and their defendants. So we're going to give them their due. This is their area of expertise. And so we're going to allow them to exercise that. But the Sentencing Commission did that. And it's okay for the Sentencing Commission to do it because Congress said they could. But Congress did not say district courts can do it. And they can't do it on their own, sua sponte. And so that's really the crux of our argument.
So is it the government's position that the Sentencing Commission could not come back after the First Step Act and remove BOP from that gatekeeping role under the catch-all? Could the Sentencing Commission do that or not? Would you say that's inconsistent with?
Oh, certainly. The Sentencing Commission could amend its rules. I guess the problem that I'm stewing over is that if you look at the First Step Act amendments, they actually still allow for a motion by BOP. And so I think it would be sort of problematic for the Sentencing Commission to say, BOP, you're completely out of the game. We're not going to let you act in this arena at all.
Oh, I'm sorry. I guess all I meant is, I may have been imprecise, and I apologize. In your view, after the First Step Act, when the commission finally does issue an applicable policy statement, could it keep everything the same for when BOP files the motion, but say that when the defendant files a motion, the defendant can get relief under A through D, and D no longer includes a gatekeeping role by BOP? So on a defendant's motion, it will be up to the courts to decide whether A through D has been met.
Yeah, so I guess the reason why that's a very difficult question, Your Honor, is it kind of creates an interesting little echo, right, in the sense that Congress said that a grant of compassionate release has to be consistent with what the Sentencing Commission says. And then I think if I understand your hypothetical right, the Sentencing Commission would then have to say it's consistent with 3582 if on an application note D motion, the district court is able to determine that, if I'm understanding you right. Mm-hmm. And, that's an interesting hypothetical because in some respects, you need the
hypothetical. It's the most, excuse me, I don't think it's a hypothetical. It is the most obvious thing that the Sentencing Commission might do when it does have an opportunity to issue a policy statement under the First Step Act for what happens when a defendant files a motion. The obvious thing, one very obvious alternative would be, now that Bureau of Prisons is no longer in charge of filing these motions, we're taking it out of its gatekeeping role altogether. And I am wondering whether the government's position is that it can't do that, that somehow we live in a legal regime under which it is permissible for the Sentencing Commission to delegate its authority to define what counts as an extraordinary and compelling reason to the Bureau of Prisons, but not to federal courts. Because that seems unusual to me.
Right. So understood, Your Honor. And again, I don't want to quibble whether it's a hypothetical or not. I guess our point only at this point is the Sentencing Commission hasn't done what you propose that it might do. And so for purposes of this case, we would just say there's really no power to do that. This court can't rewrite what the Census Commission hasn't done yet. But I also think, just sort of on a larger basis, I can't see why the Census Commission would want to do that, because then you get into the parade of horribles that we discussed, the sort of patchwork, ad hoc scenarios, and that is frankly already playing out if this regime is affirmed. In other words, in District of Maryland, and forgive me, Your Honor, I'm a little bit over my time, actually a lot, but if I could just finish this point and then I'll conclude unless there's other questions. We're already seeing these disparate activities play out. In Maryland and Virginia, stacked 924Cs were determined by the district judges to be extraordinary and compelling. Just a couple weeks ago, in a case out of the 8th Circuit, United States versus Loggins, the district court there said, no, they're not extraordinary and compelling. So in terms of just sort of a national policy.
But aren't
Your Honor.
those courts, when they say those stacked sentences either are or not extraordinary and compelling, they're looking at each individual defendant and his or her background, things they may or may not have done in prison. It's not a wholesale, in every case in the District of Maryland, stacked sentence is going to be extraordinary and compelling, or in every case in some other district, a stacked sentence is not going to be extraordinary and compelling. So the district courts are simply engaging in what district courts are asked to do, look at each individual defendant circumstances when sentencing. Isn't that right?
Well, so I disagree, Your Honor, because I think where you're going, where there is that disparateness, that's actually under the 3553A prong here, whereas what we're most concerned about as a threshold legal matter, just a pure legal statutory construction matter, are 924Cs stacked enough? And some judges are saying, yeah, they are, and some judges are saying, no, they're not.
Go ahead, Judge Diaz.
Go ahead, Judge.
So you're saying that there are district courts that are just, as a blanket rule, saying stacked sentences under 924C are enough or are too much, just as a blanket rule without looking at individual defendants?
So
and which
again,
district courts are doing that?
Right. So we're looking at the sort of the threshold question of, have you reached extraordinary and compelling or not? And then you get to those ancillary questions of, have you met 3553A? And so what I'm talking about on that first step, are we, as a threshold matter, have you established extraordinary and compelling or not? What I've seen, and again, it's very early, this case law is still developing. In both Maryland and Virginia, as you saw, the cases that are before you here, the judges in those cases said, yes, those are sufficient. And I take your point that, maybe those decisions are impacted by the individual circumstances. But again, that gets us.
The transcripts, I think, reveal that they are impacted by the individual circumstances. The judges, at least in the cases we're looking at, went into great detail about each individual defendant's history and criminal conduct in deciding. So
Right,
if you do have a district court case where the district court is just blanket saying, no, we will not do this under any circumstances, or yes, we're going to do this under every circumstance, I'd certainly be interested in that.
Yeah, and again, the closest thing I've got for you right now is that Loggins case, and I can file a 28J if the court would like. But I think in our view, it reaches that construct where you get this disparateness that the Sentencing Reform Act was frankly designed to avoid. We're getting into sort of this ad hoc patchwork system that doesn't allow.
Actually, I'm sorry to interrupt, but you've answered, at least to the best of your ability, my question. So Judge Diaz, I thought, had a question.
No, Judge, you asked a question that I was thinking about, so it's all good on my end. Mr. Mettinger, you're over your time. We're going to hear from Mr. Gleason. Thank you.
I am. Thank you, Your Honors.
Mr. Gleason.
Thank you, Your Honor. John Gleason on behalf of the appellees. Let me begin by responding to the colloquy between members of the panel and my adversaries first. And in connection with this last one, since it's fresh in my mind, all the cases with which I'm familiar involve precisely what happened in these 4 cases. Individualized, no per se determination that stacked 924C defendants are entitled to relief. But as is the case with McCoy and Bryant and Scott and Decatur, because these are not all fungible individuals. They have different measures of rehabilitation. They have different, no relevant criminal history, a near perfect disciplinary record, mentor, suicide watch companion, Craig Scott. These are individuals. And judges have made, Judge Thacker, judges have made, and we represent a number of them. And the ones in which these sentence reductions have been granted have been precisely the kind of holistic determinations that Congress vested in Article III judges, not in the Bureau of Prisons. It is true, this relates to Judge Harris's initial question. It is true, and what I'm going to attempt to do, if the court will permit me, is to root these concerns. I'm going to suggest respectfully, this isn't nearly as complicated as the government wants you to think it is. These concerns that have been expressed can be rooted directly in the controlling precedents and statutes. For example, 3553A is right under our noses. Every single sentencing, every single sentence reduction requires a judge to consider the factors in 3553A, which say that the judge must consider the applicable policy statements. And then it says, and we don't notice this, we live it every day. And then it says, taking into account any amendments made to them by act of Congress, regardless of whether such amendments have yet to be incorporated in the Sentencing Commission, by the Sentencing Commission. And Judge Harris, several judges, Judge Trenga, the ones that leap to mind, Judge Trenga in the Derek Red case, looks a lot like the 3 cases from Maryland that are before you now, but wasn't appealed by the government, said, look, we have no commission amendment. There is no applicable policy statement with respect to a sentence reduction motions made by defendants. Commission hasn't gotten there yet. There is no applicable policy statement with which the sentence reduction must be applicable. And you can rely on that. It is true that we certainly believe, consistent with 3553A5, that by taking into account a statute that was explicitly intended to take BOP out of its gatekeeper role, that even if 1B1.13 is determined by the court to be an applicable policy statement, the court has to disregard the extent to which the policy statement places BOP in the gatekeeper role that we've all been talking about. We had Judge Trenga said, this is a statute intended to remove BOP as gatekeeper. And the government, I'm sorry, this is Judge Jackson in the case before us, said this is a statute intended to remove BOP as gatekeeper, and the government is trying to entrench it as gatekeeper. This is not difficult stuff. The other sources of authority I'll respectfully suggest to the court, and this is by no means an exclusive list. There are a lot of decisions, the couple of dozen decisions in which district judges have acted on the concerns expressed by Judge Harris and Judge Thacker. But I'll suggest in the time I have available 3 principal bases for this court's authority to disregard that prefatory language in 1D and not create a different world, a world in which instead of as contemplated by the statute and the policy statement, judges decide whether extraordinary and compelling reasons other than medical condition, age, and family circumstances warrant a reduction. The BOP, the government wants that to be relegated to the Bureau of Prisons, which never opened a gate on that ground. But the other source of authority I'll suggest to the court respectfully is Dorsey. Dorsey says statutes trump guidelines, and most importantly, Justice Breyer's decision in Dorsey says, here's the key. The key is to see, you look to this, the language of the statute, the structure of the statute, its basic objectives, and give meaning to it. And it's not legislative history. The title of section of the title of the amendment to the compassionate release statute, section 603 of First Step, is to increase the use of sentence reductions. The notion that in the face of a statute specifically intended to take a gatekeeper who hardly ever opened the gate out of the middle and then say, no, 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 they remain in charge, flies in the face not only of 3553A5, but in the face of the doctrinal approach that Dorsey requires this court to take. The third basis I want to mention is slightly different, and Your Honors, it focuses on the difference between policy statements and commentary. It's really significant that what the government is relying on is this snippet of vestigial language in 1D in the commentary. And the reason is because if you read that phrase, the reason it's important is if you read that phrase in the commentary, the way these government lawyers are asking you to read it, it will bring the commentary in direct conflict with both the statute and the policy statement itself. Both the statute and the policy statement make it crystal clear that Article III judges decide whether extraordinary and compelling reasons other than or in combination with the specified ones warrant a sentence reduction. And to have just as statutes trump policy statements, the Stinson case, the Supreme Court's case in Stinson, says policy statements trump commentary. So even if the government were to succeed in its, as Judge Thacker pointed out, this kind of counterintuitive, this notion that BOP denies to make a motion on this ground, so now the defendant can go to court and make his own motion, and the judge can't decide. Even if they were right that that prefatory language in 1D said what it says, it would bring the. Yes, sir.
Mr. Gleason, I'm sorry.
All right.
Can I, let me ask you this. So could the Sentencing Commission eliminate subsection D altogether if it wanted to? What I understand from the government's concerns is that what this is turning into is a de facto parole system, which in fact, obviously Congress eliminated some years ago. And now we're reverting to a system which effectively has the same unintended effect. So would it be appropriate for the Sentencing Commission to simply say we're just going to enumerate factors, but we're not going to allow or use use of the catch-all, whether by BOP or the courts, in these kinds of motions?
Well, Judge, in my view, respectfully, I think the Sentencing Commission will do precisely what Judge Harris predicted it will do. But let me say emphatically that the current lay of the land, we're now almost 2 years past the First Step Act, and this bears no resemblance to a de facto parole system. It bears no resemblance to a system in which, as the government has argued on occasion, it's an end run around the decision not to make the amendment to 924C retroactive. We know what that looks like. We've seen it with the retroactive Fair Sentencing Act reductions. The Sentencing Commission reports that in 2019 alone, there were 2,387 sentence reductions. As Judge Jackson pointed out, our clients have been forced through a much narrower portal. And almost 2 years into it, what do we have? A couple of dozen? There's not been any. They know. We know because we screen them. They know. There's no flood of applications in the district courts. They know what it means to have to satisfy extraordinary and compelling circumstances. They know that, unlike a world in which these amendments might have been made retroactive, they know that implicates inquiry into offense characteristics, into the degree of their rehabilitation. They know how hard it is. And the data we have so far show how hard it is. And one point I can't make more emphatically, and that is this notion advanced by my adversary that if you rule against the government, it will offend the goal of the Sentencing Reform Act to eliminate unwarranted disparities in sentencing. There are no disparities that come even close to the ones produced by the government in the way it has deployed this 924C stacking provision. These sentences are breathtaking. And if I may, Your Honor, a point I can emphatically is.
Hold on a second, Mr. Gleason. We lost Mr. Mettinger, so let's see if we can get him back.
Yep.
Mike, are you there? Mr. Mettinger, can you hear me?
I can, Your Honor, and I apologize for the glitch there, and I apologize to Mr. Gleason as well. Thank you.
That's okay. Mr. Gleason, go ahead. Well, since we've got this break, can I ask you a question? You mentioned stacking and the extraordinary, breathtaking sentences, I think is the way you described it. And then you, I think, conceded quite candidly that Congress, notwithstanding the disparities that you suggest were imposed by stacking sentences, didn't choose to make the change retroactive. And so I guess my question is, what is it about the stacking, given the fact that there are a number of defendants who were subjected to it, that makes it extraordinary? And what is it about rehabilitation, which the statutes and regulations make clear by themselves is not intended to be extraordinary? What is it about the combination of these two things that suggests that your clients and other similarly situated clients really are intended to be encompassed by this catch-all provision?
Of course, and if I can append to the beginning of the answer to that question a little bit more answer to your last question. Please bear in mind that the whole point of the original enactment of 3582C, C1A, was to substitute for that opaque parole review by the commission of every sentence a very narrow judicial authority, put it back in the hands of judges, second look at a narrow subset of sentences, only those cases that present extraordinary and compelling circumstances. So it's a narrow window that Congress created by amending the compassionate release statute to allow clients like ours to make their own motion. And it is true that although rehabilitation alone by statute and pursuant to the policy statement can't be a reason for a sentence reduction, it's also obvious that rehabilitation is an important consideration and must be considered. And the second answer to your question is this. Here's what makes, it's a very small window. And truth be told, how wide that window is open to clients like the inmates in federal prisons is dictated in part by the text of the statute and the policy statement. I mean, extraordinary and compelling suggests narrowness. It's going to be informed by decisions, including by this court, as you put a judicial gloss on what it means to present extraordinary and compelling circumstances. I want to suggest to you, though, that no matter how narrow it is, it will include cases like the ones before you now. And that's because for decades, Judge, these extraordinary, and so extraordinary that the Congress eliminated them, these extraordinary enhanced sentences have never been they've never been based on a defendant's culpability, on a defendant's the offense conduct. For decades, they've been used by the Department of Justice by reference to one fact and one fact alone, whether a defendant pleads guilty. They've been used, these bone-crushing 20 and then 25-year enhanced sentences are used to induce people to plead guilty. You have before you Thomas McCoy, worked for him. He took 32 years guaranteed, but if he went to trial on his 12 924Cs, he would have had 282 mandatory years. And they've been used to punish people who don't plead guilty. Read Keith Bryant, Craig Scott, and Cottrell Decatur, who got their 50-year sentences plus because they went to trial. And so in addition to their unusual length, yes.
Counsel,
yes.
I want to back you up for a second, if I can, to Judge Diaz's question about whether the commission could, if it wanted to, just get rid of the catch-all provision altogether. But let me, what I'm really trying to get my hands around, and it's related to that question, is it seems to me there are sort of two different theories under which you could be going, and I want to make sure I understand which one it is. One would be to say, look, the Sentencing Commission has not made a judgment here that when a defendant moves for a reduction, the defendant can't invoke the catch-all provision unless BOP approves. We don't have a commission policy saying that. So there is nothing here to bind the judges. Another way to think about it would be that the commission can't have a catch-all provision that uses BOP as a gatekeeper, period, after the First Step Act. It might be able to get rid of the catch-all provision entirely, but the one thing it cannot do, consistent with the First Step Act, is put the Bureau of Prisons in this gatekeeping role in between a defendant-filed petition and relief. So, on one theory of your case, the district courts can do what they want here because the Sentencing Commission hasn't said anything. On another theory, it would be, look, we can maybe assume that the Sentencing Commission wanted this to continue to apply. No reason to do so, but we could assume that, in which case it would just be inconsistent with the First Step Act to maintain the catch-all with the BOP gatekeeping requirement. So which is your, and maybe you're arguing under both, but which theory are you pushing?
Yes, you can affirm on either ground. And the notion that you mentioned at the outset, that there is no applicable policy statement, has great traction. No question about that. And some district judges have relied upon it already. But I'm suggesting to you that even if 1B1.13 is the applicable policy statement, you have to read out, just as we read out the upon motion of the Bureau of Prisons, which is in there 3 times, you have to read out, you have to take into account, as 3553A5 says, the acts of Congress that are inconsistent with it, whether the commission has acted or not, and that's what's applicable. So the applicable part of the applicable statement does not bind the judges. To go back to the question
I'm sorry,
to
can
Judge.
I have one follow-up. There's a sense in which, as we look at this new statute, there's not a lot of law under it. It would be somewhat narrower, right, for us to hold, there's no commission policy statement here, period. And that's what allows the district courts to kind of exercise their discretion here without reaching the question of whether the commission could, when it has a chance to issue a policy statement, keep the BOP in this gatekeeping role. I mean, it would be a slightly smaller decision, right?
Well, Judge, I don't see why you would ever reach the decision now, in this case, whether in the future the commission could permissibly eliminate subsection D. And by the way, it couldn't.
Oh, that's not what
Because I'm with you. I go back to the statute. The face of 3582C1A, and we know from the legislative history, it was intended to allow a judicial second look for unusually long sentences, among other things. And the face of the statute says a judge in any case, when determining that there are extraordinary and compelling reasons warrant a reduction, can do so. Now, is the commission authorized by 994T to articulate criteria? Yes, and it did. And it says in the background note at the end of 1B1.13, we did our job. Here are the criteria: age, medical circumstances, family circumstances, reasons other than or in combination with those. So in the future, could it backtrack and eliminate D? I don't know why it would, but the last thing that's before this court now is projecting what the commission could do or might do and ruling on my challenge to a commission decision to eliminate subsection D entirely. The last thing I want to say, I see my time is up, is almost up, or is up. I can't tell what these lights are, but if I may, Judge Diaz, can I make one more point to go back to the other point? And look, I'm going to call the government out on this, and with all respect, so should this court. In addition to the unusual length of these sentences and the disparity the government produces by using these 924C enhancements to procure guilty pleas and punish those who don't plead guilty, it's a blight on our system. There is this sordid, racially discriminatory deployment. Part of it's set forth in our brief. In 2004, the commission doesn't often ring alarm bells on behalf of defendants. In that 15-year report, it said this is deployed for decades in a racially discriminatory manner. Black men comprise 48% of those who are eligible for 924Cs, but they're 64% of those who get stacked 924Cs. In that humongous 2011 mandatory minimum report to Congress, the Commission said it's still happening. It's still racially discriminatorily deployed. And Congress, this is the Commission, says to Congress, you should get rid of this. You should allow it to be concurrent. You should lower these sentences. You should make it a true recidivism statute like it eventually did. And the last piece of this, Your Honors, and I'm sorry it's not in our brief, but it's a report on the Commission's website from March of 2018, 10 months before Congress amended the statute. 10 months before Congress amended the statute. And it says it's still happening. The racially discriminatory use of this statute is still happening. So 10 months later, finally, Congress does something about it. And I'm going to suggest to you, you look at this brief, there is no sense in which there's any claim of abuse of discretion in Thomas McCoy's case. But you look at the description of the crimes. His robberies resulted in a guideline range of 37 to 46 months because the robbery guideline takes care of things like described in there. And you see these words in there: predatory, terrorizing, ambush. It's all of a piece with the deployment of these ridiculously harsh sentence enhancements that have now been eradicated that makes these cases, I'll suggest respectfully to you, Judge Diaz, makes these cases more likely than most to fall comfortably within, no matter how narrow this court decides, extraordinary and compelling reasons other than age, medical condition, and family circumstances, how narrow that is. These cases, more than any other, provided they have the kind of remarkable rehabilitation you see on the part of these four men, these cases are likely to fit within it. I see my time is up. Thank you for letting me go over time.
Thank you, Mr. Gleason. Mr. Attias, you have some rebuttal time. Go ahead.
Thank you, Judge Diaz. If I could just address two questions the court asked before addressing Mr. Gleason's point. Judge Thacker, you asked whether Congress intended to undermine subdivision D and how we could be so confident that it didn't. And I wanted to point out that we know that Congress didn't intend to override subdivision D, because if it did, it would have said so. And the best evidence of that is Section 8 of the Fair Sentencing Act, which directed the Commission to promulgate guidelines to reflect new minimums as soon as practicable. In fact, Congress gave the Commission emergency authority to do that. It did nothing of the sort here. And that silence, I would say, is telling, and it's brought into starkest relief here in light of the fact that the First Step Act cites the BOP over 100 times. It's simply impossible to think that Congress forgot about the BOP in its subdivision role. Judge Harris, you asked if the Commission could amend subdivision D to reflect that courts can determine their own criteria for compassionate release. And I think that if the Commission did do that, Congress would have to amend Section 994T to reflect that other bodies of government can also promulgate substantive criteria. And it would also have to amend 3582's requirement of consistency with the applicable policy statements, because it would likely render it absurd and superfluous. And the reason for that is that if all a district court had to do to comply with 3582's requirement of consistency is be consistent with their own determination that extraordinary and compelling circumstances exist, it would render the requirement a nullity and likely superfluous. So in that sense, it would invite conflict with the statute. Mr. Gleason talked about the 3553 factors, and I think that brings up a critical error in this case, which is that the district court viewed a disparity issue under the factors as somehow conferring eligibility under 3582, and that's precisely the opposite. And we know that because Dillon tells us that, as did this court in Clausen. First, we determine eligibility under the policy statement, and any concerns that a district court has under the factors are subservient to that. And the best evidence in the McCoy case is JA 165, which is that the district court put the 3553 factors as the first section in the discussion portion of its analysis, which is extremely telling in this case. Mr. Gleason also talked about the text and structure of the First Step Act, and I think that's helpful because the text of the First Step Act in Section 403 and this court's case in Jordan tell us that retroactive 924C amendments don't apply to defendants like Mr. McCoy who were sentenced before the act. And as for structure, the very next provision, Section 404, tells us exactly how Congress structures a case-by-case mechanism for defendants to benefit from retroactive mandatory minimums. Compassionate release is just not that statute. And finally, Mr. Gleason talked about the commentary. Yes, the commentary is authoritative under Stinson unless there's a conflict. And there's absolutely no textual conflict in this case. The only way to find conflict is if you assume that Congress's procedural amendment intended to have substantive benefit. And if you accept that, you have to accept everything that goes with it, which is that 994T doesn't mean what it says, and the absurdity of requiring courts to be self-consistent with their own determination. Yes, Judge Harris.
So I'm sorry, I'm going back to the Jordan point and the fact that Congress didn't make the stacking change retroactive. I mean, it's all part of the same statute, though, right? So these Bryant defendants, right, are serving a 45-year minimums, and Congress has now made the judgment that that's 40 years more than is appropriate, right? They should have gotten a 5-year mandatory minimum. They got 45-year mandatory minimums. So they're 40 years off from where Congress thinks it should be. And in the same statute, Congress says we're not making that retroactive, but we do want more compassionate releases. We want more use of that individualized safety valve. So why isn't that just sort of a perfect congressional compromise? We're not open. We understand there's a big mistake here. We want to clarify that this never should have happened. We don't want to open the floodgates and let everybody out automatically, regardless of individual circumstances and risk to the public. But in the very same statute, we absolutely want to expand this safety valve for individual cases. Why would it be that in employing that safety valve, you can't turn around and look to what the exact same Congress did in the exact same statute when it said, oh my goodness, these statutes, these sentences are off by an extraordinary factor, truly extraordinary.
So my first point, Your Honor, is that I think Jordan actually addresses this, and it states that the reduction in criminal penalties is always going to pose difficult line-drawing questions. And
I'm sorry, I'm just having a little bit of difficulty hearing, and I don't want to miss this. Can you?
I said the opinion in Jordan writes that the reduction in criminal penalties is always going to pose difficult line-drawing questions. And so Congress obviously was faced with this issue.
Well, I am so familiar with that opinion, as you know. And the point was, there's a reason why Congress might not want to open the floodgates. And it's always going to have to draw a line between people who will automatically be released from prison and people who will not. But Jordan certainly didn't say anything suggesting that having drawn that line as to automatic vacating of all of these sentences would somehow constrain judges from taking account of this new policy judgment by Congress under the compassionate release provisions.
Your Honor, I would agree with you if Section 404 didn't exist, because Section 404 is exactly the type of mechanism you're describing. It's a
Section
discretionary
404
system.
is so much broader. That is a much, just going back to your colleague's metaphor, that window is wide open. That's just sort of, it's at the court's discretion. There's no requirement that you find it extraordinary and compelling. That's what Congress does when it wants the window pretty far open.
I think 404 is a good example of how Congress structures that sort of mechanism. It might be broader, but it easily shows that Congress knows exactly how to tailor these types of procedures. It made a very broad one under 404, and it could certainly make a narrower one under a 405 or 403.
Although if it thought it could have thought extraordinary and compelling is the right window for this, but we are paying attention to it at the same time that we are changing the stacking provision. We do want to be clear that we want that extraordinary and compelling provision to be used more often. And we want to do it by getting rid of BOP as the gatekeeper. I just don't see why it would have been necessary for Congress to have done more than that. If they were comfortable with extraordinary and compelling, that's where we want to set the window. We just want to get BOP out of the picture.
Judge Harris, this court in Goodwin has refused to read silence as permission in 3582 context, and I think that's directly applicable here. If Congress intended to create that type of system or for 924Cs to constitute extraordinary and compelling circumstances after decades of cases stressing the finality of sentences and judgments, and where sentences are final unless Congress explicitly says otherwise, I think it would have said so. And I hope that answers Your Honor's question. I just wanted to make one more point as to Mr. Gleason's point that compassionate release is a second chance or a second look. There's simply no evidence that compassionate release was ever supposed to be anything like 2255 or direct appeal. He stated that in his brief and stated that here today. There's simply no evidence other than a single piece of legislative history. As for the point regarding abuse of discretion, if this court sidesteps the issue of conflict, it could nonetheless hold that the district court committed a legal error in effectuating non-retroactive statutory amendments via compassionate release. And so in that sense, it would be a per se abuse of discretion.
Thank you very much, Mr. Rattias. I want to thank counsel for their very able arguments here today. The case has been submitted. And Mr. Gleason, in particular, I want to thank you for your willingness to take these cases on pro bono on behalf of both your clients and the court as an institution. Obviously, it's critically important that lawyers be willing to render such a valuable service as you have here today. So thank you on behalf of my colleagues in the Fourth Circuit. We would traditionally come down from the bench and greet you all individually. Obviously, we cannot do that under the circumstances, but please know that that we are, again, grateful to you. We wish you the very best and that you remain safe and well. And thank you again for your arguments. The court will stand in recess.
Great.
Thank you, Your Honor.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, good morning. We're prepared to hear argument in our third case, Young versus Equinor USA Onshore Properties, Inc. Mr. Lynn, whenever you are ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is Albert Lynn, and I'm here on behalf of the defendants. This case raises several questions of first impression about a decision of the West Virginia Supreme Court of Appeals, the estate of Tawney. And we think there are three ways, respectfully, to decide this case. First, because the parties waived the implied duty to market for the life of the lease, Tawney simply has no application here. Second, even if Tawney applies, its requirements were satisfied. And third, this court could instead certify to the West Virginia Supreme Court of Appeals because this case raises several questions of first impression, and the West Virginia Supreme Court of Appeals has expressly called Tawney into question. Yes, Your Honor.
Of those three avenues, which is your preference?
We think the easiest is the waiver of the implied duty to market, although we do think we would certainly all three of them are acceptable to us, whatever the court prefers. So if I may, Your Honor, I will turn first to the waiver of the implied duty to market. We think because of that waiver, Tawney has no application here, and I would start, Your Honors, with, I think, two critical concessions by the plaintiffs that narrow the issues. The first is they concede that Tawney is premised on the implied duty to bring gas to market. And then secondly, they concede that the implied duty was, in fact, waived for at least part of the life of the lease. So the question on this for the court is whether that waiver extends into the current period that we're in. And we think the answer to that is clear for at least three reasons from the lease language. The first is if Your Honors look at the lease development provision, it says that there is no implied covenant to market within the primary term or, and here's the operative language, any extension of term of this lease. And so the three reasons are, one, I think any extension of term of this lease on its face refers to the lease term, which is defined as the life of the lease, and I'll come back to that. The other two reasons very quickly are the district court and the plaintiffs contend that that extension provision only refers to extensions of the primary term. But in the lease, there is a struck-through provision that uses specifically that phrase, extension of primary term. So I think when the drafters wanted to say that, they knew how to say it. And then third, I think the consequences of the district court's reading and the plaintiff's logic don't make a lot of sense. Their view is that the implied duty was waived only during the primary term and any extension of that primary term, but it springs back to life in the current period or the secondary continuing term. And there's really no logical reason why an operator would agree to something like that. But I do think this, yes, Your Honor.
Can I just ask you a quick question about the language that you were just quoting within the primary term or any extension of term of this lease? It looked to me like there was a word missing between of and term. Shouldn't it be something like any extension of the term or any extension of this term or any, is there a word missing?
I don't think so, Your Honor. I think you put your finger on an important point. I think the fact that it doesn't say any extension of a term or that term, I think what it's trying to say is term of this lease. And I think term of this lease is admittedly a somewhat awkward and more wordy way of saying the lease's term, right? So like a child of this father, or the father's child. I think that's why there is no article there, whether it's a or the. It's referring to the lease's term. And lease term, Your Honor, is a defined term under the lease. On the very first page of the lease, it actually says lease term in about halfway down that page. And it defines that lease term as basically the life of the lease. This lease shall remain in force for a primary term and shall continue beyond the primary term if any of these various conditions come to pass. And it actually goes on to say that, you know, if one of the conditions is true, it sort of subsumes within the concept of the generic lease term these more specific ideas of primary and secondary terms. So I think, Your Honor, to answer your question, I think that actually was intentional, and I think what it's doing is, it is, and I will admit freely, that it is a somewhat awkward way of saying the lease's term, but it is defined, it is, you know, grammatically, that's what it says. It's a possessive. It's saying the possessive, you know, the possessive of lease. And so it's referring to that term. And so I think, Your Honor, when you look at just that plain language in that clause, it's very clear that the implied covenant has been waived not just for the primary term, as the plaintiffs concede, but for the full life of the lease. And if that's true, because Tawney is premised on the implied duty, and if you look at Tawney, I think that's clear, and I don't think plaintiffs can contest that. They say at page 8 of their opposition that the reason for these requirements is because of the implied duty. And Tawney actually, when it was answering the certified question, it actually reframed the question to incorporate the implied duty as a premise to the question it was answering. It says, in light of this implied duty, is this language that's at issue here ambiguous? And so yes, Your Honor.
Well, I mean, it seems to me that implied duty or not, that once the lessee does begin to market the lease, market the oil and gas, there has to be some method by which to calculate the costs, and whether pre-production or post-production. So I'm not sure that that's helpful if, in fact, your client has begun to, begin activity on the lease. At that point, if there's going to be a dispute about who bears what cost, don't you think it is important to at least have some basis for assessing that?
Absolutely, Your Honor. I do think the sort of obviously concepts of notice are important here, and it's important that it's clear from the lease that the parties agreed to share the costs, what those costs would be, and how you would calculate those costs, as you point out, Your Honor. Our point on the implied duty is, I think, because ultimately the question that's raised by the district court's opinion here and by the plaintiffs is that there is, that this lease fails the requirements of Tawney. I don't think the requirements of Tawney, which put a thumb on the scale in favor of requiring extra clarity, I don't think those requirements apply. But we can, Your Honor, yes, Your Honor.
I think I'm asking the same question, but I had the same question. I want to make sure I understand the answer. So even assuming that the implied covenant has been waived, right, it's not your position that that automatically shifts post-production costs over to the landowner. It just gets you out of sort of a clear statement rule, and now you just look at the contract to see if the intent is clear that the landowner is going to bear these costs. Is that right?
Yes, Your Honor, that's right. That's right. I think it takes that clear statement rule away. And so to the extent that the district court relied on that clear statement rule, which I think it did, to impose this very, very specific and onerous requirement of articulating a mathematical formula, I think that goes away. And I think when you look at the terms of the contract, which I agree, Judge Diaz, you do have to obviously look at those terms, I think it is clear that the parties agreed. There's no dispute here. If we just want to talk about it, since I think it makes sense just to move into the framework of Tawney, I think there's no dispute here as to prong one that the parties agreed and that there's sufficient notice in the contract that they would share post-production costs. The real action here is on prong three, Judge Diaz, as you referred to, this question of the method. Is there enough here that indicates the method? And I think it's important just to take a pause here and point out that I think the district court and the plaintiffs are, before this, at this point, complaining about two different things. The district court's issue seemed to be with whether there was enough in the contract to indicate the method of calculating the bucket that constitutes post-production costs. So what is that? The plaintiff's brief seems to have abandoned that, and instead their complaint is about whether the lease has enough to give notice of the fractional share of that bucket that will be borne by the plaintiffs or the landowner. And I think we can turn to that first, the plaintiff's complaint. And I think that's all this court needs to reach, given the way that they've decided to plead the issue here. And they concede that this formula that we articulate at page 10 of our brief that sets forth how you get to the fractional share of the post-production costs would be enough. And they say that at a couple places in their brief that would be enough, but they say it can't be found in the lease's terms. But I think, Your Honor, as we point out in our reply brief, it can be very easily from 3 provisions of the contract. The first is the provision that discusses the royalty, and that says that the royalty is going to be 14% of the gross minus the post-production costs. So if you do I think it's basic arithmetic here, that means 14% of the post-production costs. Then you look at the provision that's entitled payment reductions, and that is the provision to account for the possibility that a plaintiff may not own the entirety of a piece of land. And all it says is, in that case, you get whatever proportional share of the royalty that is equal to the proportional share of your ownership of the land. And so that's X percentage times Y percentage. And then the third fraction comes from the utilization and pooling provision, which is similar to the payment reduction provision. That's the one that says that if you've pooled the various pieces of land together, of course, you're only going to get the royalties that reflect the proportionate share of your section of the pool. So that's another fraction. That's, call it Z percentage. And that's it. And the lease, I think, clearly articulates those 3 fractions, and you multiply them together, and that gives you the ultimate fractional share. And I think, to answer your question, Judge Diaz, I think that with or without Tawny gives sufficient notice of how, the method, how are you going to get to the fractional share of the post-production costs that are going to be shared, that are going to be borne by the landowner here.
No.
Yes, Your Honor, of course.
So if this is also clear as to how it should be determined, why is it that in your brief you argue that Tawny establishes a standard that no lease could satisfy? I thought you just found a way that this lease could satisfy the Tawny standard.
Your Honor, let me see if I can clear that up. I think
Yeah,
what
maybe
we were
I'm
arguing.
Go ahead.
Your Honor, well, I think what we were arguing is that the district court's view of the sort of mathematical precision that is required, that reading of Tawny could not be satisfied because you cannot calculate at the outset specifically what they're going to be required to pay in terms of post-production costs. I think what a method is referring to is something at a little bit of a higher level. I think things that are methods are a proportion or an apportionment, or all, for example, would be another method. And I think this, just to be totally clear, is not the argument that the plaintiffs are making now. I think, again, the plaintiff's complaint is about whether the fractional share is clear. But in terms of the district court's complaint, is there enough here to demonstrate how you're going to calculate that bucket that constitutes post-production costs? I think it's there, and I think there's 2 ways that are articulated in the lease. One is for post-production costs that are contracted out to a third party, and the other method is for post-production costs where the operator uses its own infrastructure. As to the first part, post-production costs done by a third party, what it says is all costs and expenses relating to these various things: separation, transporting, treating, process, but the method is all. And as I said, I think that's a legitimate method. Another method could be half. Another method could be proportional to the distance of the pipes. But this method is all. So for third-party post-production costs, it's all. And then that same paragraph goes on to say, of course, an operator can use its own infrastructure to do these various things. And if it uses its own infrastructure, then the method is reasonable amortization, reasonable depreciation, a reasonable rate of return. And again, those are methods. I think if you were to talk to any accountant, they would say those are methods of calculating. I don't think what the normal contracting principles or even TANI would require something, very precise to like tell the landowner exactly what the costs are going to be. These are methods. These are mathematical methods. All sum, proportional, reasonable amortization, reasonable depreciation. So I think as to both pieces of this, whether it's the district court's concern about whether the lease has enough to indicate the method to calculate the bucket of post-production costs, or plaintiff's new concern about whether the lease has enough to indicate the method of calculating the fractional share that is borne by the landowners. I think both of those are clear from the lease. And I see my time. Yes, Your Honor.
I think you hit on this at the very end, but overlaying all of this is obviously the landowners aren't left without a remedy with respect to these costs if they feel that they are excessive, because there's an element of reasonableness to all of this, right? That you would have to satisfy, and you could litigate that, but the math is there. It's just a question of whether or not the lessee is acting reasonably in expending those costs. Is that right?
That's right, Your Honor. If I may answer.
Go ahead.
Go ahead. Yes, Your Honor. And I think both sides actually agree on that, and the district court recognizes it too. The Wellman case, which is the predecessor case to TANI, says that, on top of all of this is, Your Honor, this back-end check of one, reasonableness, and two, actually incurred. You can't simply charge them for something that you did not actually incur, and that's a remedy that the plaintiffs could seek once the post-production costs were deducted.
All right, thank you.
Yes, Your Honor.
You've got some time left for rebuttal. Mr. McGraw, whenever you're ready, go ahead.
Thank you, Your Honors. May it please the court, Jeremy McGraw on behalf of the appellees, the Youngs. Despite some of the ways that the appellants try to characterize the district court's rulings, I don't think that there was anything.
Mr. McGraw, let me just, we can hear you fine. The video, at least on mine, is not coming across all that clear, but we can hear you. So I just wanted to let you know that. Go ahead.
So thank you, Your Honor. I just wanted to say I don't believe that there's anything controversial or confusing about what the district court did. I don't think there's really any conflict between what we're arguing in our briefs and what the district court did below. The district court did exactly what it was supposed to do under West Virginia law, sitting in diversity. It was required to take the clear controlling authority and apply it. And I think they did that in this case. Now, there was a question about that lease development clause and whether there's some wording missing there in that extension of term. There's a couple reasons why I think that at best that lease development clause language is ambiguous. The first being you've got this statement that there's going to be no implied covenants, quickly followed by a second statement that says there will be no forfeiture, termination, or expiration. Obviously, if there's no implied covenants, you're not going to have those other things. So what is the purpose of that second sentence? The reasonable reading of that second sentence is that those things do apply at some point. And I think this gets into that confusion there about whether there's any word missing in that extension of term. The primary term of this lease, and the primary term under all leases, is a situation where this oil and gas company has paid for a right to delay its decisions as to whether it's going to make operations. So it certainly makes sense and it's reasonable that they would not want to have any of these duties, implied duties or other obligations during that time. But once they decide to take those operations and move forward, and this lease moves into what's called the secondary term, those obligations would jump back in. There's nothing confusing about that. It certainly makes sense that when this lease goes into the secondary term, they've got a different set of obligations, because at that point, they are required to act. They are required to do things. They're not required to do anything during that primary term. During that primary term, the lease will either expire at the end of the date, or it will switch over to the secondary term when the certain operations have taken place. Council talked about this extension of primary term and the lease term language talking about going beyond
Mr. McGraw?
Yes, Judge.
Mr. McGraw, I have a question. You and perhaps Mr. Lynn as well think that Taney is clear and controlling authority, but what about the fact that Taney has been criticized by the West Virginia Supreme Court itself? Isn't that a reason to certify all of this, or at least the question of Taney's import and meaning, to the West Virginia Supreme Court rather than have us muck around in what is a uniquely West Virginia issue?
I don't think that it does, because the West Virginia Supreme Court in the Leggett decision specifically said Wellman and Taney are unaffected. There's still valid law on those points as it stands in West Virginia at this point. The issue of certifying questions is whether or not there's no controlling authority or confusing control authority. I don't think there should be any dispute that Taney is still the controlling law on this issue in West Virginia. Whether or not the West Virginia Supreme Court might do something else in the future is a different question, and there was certainly a whole lot of history into how the Leggett decision came about based on rehearings and elections and a lot of things going on politically here. But the case law in West Virginia...
Well, we do have, that's the nature of our Supreme Court in West Virginia. The Supreme Court, I guess, in West Virginia.
And you are correct, Your Honor. And actually, after that time, there's been some steps to try and make it a little less political, including nonpartisan elections. But the district court took the law from Taney, took the law in Leggett that said Wellman and Taney are unaffected, and applied it. There's no reason that this court can't do the exact same thing. And I would remind the court that we filed this case in state court. We were in the West Virginia state court system. The defendants removed this case to the federal court system. They asked for the federal court jurisdiction. They asked the federal judges.
As they're entitled to do.
And they never asked Judge Bailey to attempt to certify this question. It was only after they got the ruling that they didn't like that they asked for certification.
Does the fact that they didn't ask the district court to do that, does that mean that we can't certify the question?
No, it certainly does not.
If we wanted to? Okay.
No, it certainly does not. You have the discretion to do that as well. But I think if you look at the Certification Act and the reason for those rulings, it's when you have this issue and there's no controlling authority that applies. Here you have very specific, not very complicated controlling authority that tells you exactly what you've got to do and what you've got to include in these leases. Yes, Judge.
So going to that point, like your colleague, I read your brief to be saying that it would be enough under the third prong of Taney if a lease made clear how it was going to determine, how it was going to apportion costs among various I get lessors and lessees mixed up, landowners, among various landowners. And that the problem here is that the lease didn't make that clear. Is that your position?
That is correct. It is our position that under Taney, that the third step is to indicate the method of calculating the amount to be deducted. So they want to point at this language and say all costs and then this list of costs. The question is not that they're going to take out costs. The question under Taney was, how are you actually going to allocate and apportion that cost to this individual landowner? And that is what is missing from this lease agreement. They want to point to this paragraph K, the payment reduction clause, which absolutely never mentions costs at all. It really only applies for situations where an owner may or may not actually own the full mineral interest. Say a later title search shows that they only own 50%. Even though you signed a lease for 100%, they're not going to pay you the 100%. They're only going to pay you on your 50%. They look at the pooling and unitization clause. Again, the pooling and unitization clause never mentions costs or deductions. What the pooling and unitization clause does is it allows the operator to combine this property with other properties, and then specifically states that the lessors, the royalty owners, are going to share the revenue from these wells based on that proportion. The dictionary definition of revenue is even a total amount. So I don't think that there's anything in those two clauses that get them to this idea that this lease clearly says that they're going to proportionately share costs. Had they just put it in there, that would have been enough. Had they put in the lease the language that Mr. Rickman put in his email to my client when my client questioned this, that would have been enough. I mean, and that specifically said, yes, Your Honor.
I'm sorry, so just so I understand the position. So I don't understand, so if we were in a case where there's only one landowner and there's no pooling, so it's just one landowner and no pooling of costs or anything, then why wouldn't it be enough if you just said all costs? Like the way I'm distributing the costs is the gas company pays none and you landowner pay 100%. That seems like it would be enough.
I don't think that it would, because I think all is still the descriptor of the types of costs. It doesn't get you to the method of how they're going to be attributed.
If it said
to the person.
100%, the way the distribution will be as follows. The gas company pays 0% of the post-production costs and you landowner pay 100%. That would be fine, right?
I would think under Tawny that might actually apply.
Okay.
That might be good enough. But that's not the situation that we have here.
I understand, but so the only problem you see here under Tawny is that you don't think it's clear enough how the cost will be apportioned among various landowners.
Well, and how it's specifically going to be apportioned to this landowner too, because it doesn't, it never actually says we're going to charge you 14% of the cost. That's more language that they're trying to draw and pursue from other parts of the lease. So they're not saying they're going to pull all costs. What he said today was we're going to pull 14% of all costs. It never really even says that in the lease agreement. I don't mean to belabor a lot of the issues. Yes, Judge.
Is there a case that you consider controlling on how the third prong of Tawny is to be applied?
I do not believe that there is a specific case that has interpreted that, but I don't think that that means it needs interpretation. It's a pretty clear statement from the West Virginia Supreme Court. It really didn't use complicated language to describe what was required.
I think you all have spent a lot of time and litigation on what you say is a pretty clear statement. It's not that clear to me still.
Wait. Yes, Judge Harris.
I mean, the district court, right? It seems like the district court had something very different in mind. As I read the district court opinion, it did seem to be saying, like, it's not enough to say how you're going to apportion costs. Like, I don't know what exactly the district court had in mind, but I think it was more like, tell us how you're going to figure out how much it will cost to do these things that you've listed in 2. Yeah, I thought the district court was reading it differently than both of you are reading it today. But you think the district court was reading it the same way you're reading it today?
I do. I don't see the discrepancy. I do believe that the district court was mainly concerned with determining how you're going to come up with this amount that's ultimately going to be deducted from the royalty share. And I don't think our statement of how that is done in the brief is really inconsistent with what the district court said. I don't think
What about all that business about uniforms and employee meals and stuff like that? You think all of that went to how are we going to know in a pooling arrangement how much each landowner pays?
I think that was just more of a general statement of the uncertainty that lies in these issues with post-production costs. You've got an asset that this royalty owner owns. They enter into what is essentially a business agreement to allow someone else to produce that. And now this third party is going to take all these deductions out and not really give you any accounting as to what those things actually are or an explanation in advance as to how they're going to do that. So I don't think that was a specific statement that in this case I'm worried that they're going to take out uniform costs and we don't know how they're going to do that. I think it was just more of a general statement of that's the type of problems you get into in these cases when you have the gas companies guarding the henhouse on these costs and expenses. And, you know, in actual practice, you see landowners losing 50, 60, 70% of their royalties to these post-production costs. Getting back to that third point of Tawny, you know, the language there was just to indicate the method of calculating the amount to be deducted. I don't believe that that's very confusing language. The district court looked at the dictionary definitions of method and calculating. The appellants want to ignore those dictionary definitions while looking just at the dictionary definition of indicate. I think when you combine those 3 dictionary definitions together, you get even more of a clear statement that what we're all looking for is a process, a procedure, a technique for how you're going to mathematically perform this. I would agree that at the time you enter this lease, you're not going to know what exactly that decimal number is to be able to make that final calculation. But you at least should state in the lease that that's how we're going to do it. We're going to take your decimal interest of ownership, multiply it by the costs, and that's going to be your share of what you actually pay in this case. That is not an onerous standard. That's something that's easy to meet, and they took steps to do so in an email to my client and in their brief. All they had to do was actually state that in the lease agreement, and they would have been fine. But they did not do that, and it's a failure of drafting on their part, and to the extent there's any ambiguities, it goes against them.
Mr. McGraw, just so I'm clear about what your position is here, so your view is that your client could reasonably, or doesn't really know whether or not the lessee in this case intended to deduct all, some, or part of the cost? Is that the argument?
That is part of the argument, yes, Your Honor. So when they see this agreement, there's something that says they're going to take out all these costs. There's no explanation as to how that's actually going to be apportioned or attributed to you and your royalty share, which is what that third element of Tawny was looking at. And especially in this case.
But the lease itself, it talks about the net amount realized by the lessee, and then it talks about how to get to that amount, and it says the gross proceeds received by the lessee from the sale minus post-production costs incurred by lessee. That would suggest that there is no fractional allocation of costs. It's the entire amount of the cost. And then so you deduct those two amounts, and then you calculate the royalty by multiplying times 14% and making the divisions among the various landowners. That doesn't seem all that difficult. Well,
I don't even think that that's the position that they've taken today. Their position is that they're not taking out all of the costs. They're only going to take out 14% of the costs. I just don't see how stating we're going to take all of these costs is a method of calculating
they're allocating
how
14% of the cost to your client ultimately because that's the amount of the royalty, but they begin with a deduction of all of the costs, I think.
That's certainly part of the position they've taken today, that they can take out all of these costs. But as I said before, I don't think this lease ever goes on to fully explain that they're only going to take out, they're going to apportion those costs to the landowner in proportion to what their ownership interest is in this unit. Because you're not talking about one well on one piece of property. You're talking about a couple wells covering 600 acres of property. They don't keep expenses as it relates to each individual property. They keep expenses as a gross, as a whole unit, and then they're creating this way to try and allocate that back to the landowners, but they never explain to the landowner in the lease agreement that that's what they're doing. And I think that's where they fall flat under the third element of Tawny, which I don't think is very confusing and complicated. It's just indicate the method of calculating the amount to be deducted. So it's not a calculation of how you get to your royalty payment. It's a calculation of how you're going to get to that amount that is deducted to finally get you to your royalty payment. Which again, I believe, had they included that explanation that they did in the email to my client when he asked about that, had that been in the lease agreement, that would have been good enough, but it's not in the lease agreement. As try as they might to reach out to these other provisions of the lease, those other provisions of the lease never mention costs. They never make this assertion that they're going to split this up proportionately. Those other provisions are all talking about how the owner is going to get paid, whether or not they own the full interest, or how that owner is going to share the revenue from the wells with all the other owners, whether or not the well is actually located on their property or not.
All right. Do either of my colleagues have any additional questions? Doesn't look like it. Okay, thank you, Mr. McGraw.
Thank you.
Mr. Lynn, you have some time for rebuttal. We can't hear you, Mr. Lynn.
Sorry, I was on mute. I need to learn from my own children who even get that right. Just if I could just cover two things. I'll start on the certification question, Judge Thacker, and your question about whether there's controlling authority here. And I think I heard my friend say there is no controlling authority on the meaning of indicate the method. And I think the important way to think about this is Tawny, in this case, is like a West Virginia statute that's being applied. Tawny is the original thing that's being applied. There is no case that interprets that statute, in this case, that rule in the case. And the only thing we know from the West Virginia Supreme Court about Tawny is that they think, a majority of that court thinks that it's faulty and suggests that they may even want an opportunity to overrule it. I will also note, we do think that wherever the line is for indicate the method, that we are well past that, which is why we think it's clear, Judge Thacker. But to Mr. McGraw's point, I don't think it's really that obvious where that line is. There are 2 district courts in West Virginia that have disagreed about the meaning of indicate the method. Judge Bailey in the decision below specifically disagreed with Judge Goodwin in the W.W. McDonald case out of the Southern District. As to the method, Judge Diaz, I think I wish I had said it as clearly as you had. That's exactly what we think the lease makes clear. And if I could kind of, I think about things in a mathematical way, but I think really it's a formula where you get the pieces from the lease. What the lease says is that the royalty is the gross proceeds minus the post-production costs. How do we get the post-production costs as part of that formula? It's all of the third-party post-production costs and expenses for the various things that are listed, treating, separating, transportation. And then it's if the the operator uses its own infrastructure, it's reasonable amortization, depreciation. That's how you get to that number, the post-production costs that you subtract from the gross proceeds, and then some portion of that is the royalty. How do you figure out that portion? 14% times if there's some fractional share of the property, and then times if there's some proportionate share of because of pooling. And Mr. McGraw, my friend, says that neither the payment reduction provision or the utilization and pooling provisions refer to costs. That's true, they don't say cost, but what they refer to is royalty. And they say in both places, royalties, this is the payment reduction provision, paragraph K, royalties hereunder shall be paid to lessor. Judge Harris, the landowner, I get those things confused myself. Royalties hereunder shall be paid to lessor only in the proportion which lessor's interest bears to the whole and undivided fee. That's the percentage of the royalty if there's some ownership that's less than the whole. Utilization and pooling, same thing. Lessor agrees to accept and receive out of the production or the revenue realized from the production of such unit, such, quote, proportional share of the royalty. And it goes on to say, as the number of leasehold acres included in the unit bears to the total number of acres in the pool. So what we're talking about is, again, if you're part of a bigger pool, you have to do that percentage as well. So it's 14% of the whole thing gives you the royalties, and then if there's some reduction for property, some reduction for pooling. So I think all of these pieces are in the lease, but Judge Thacker, if there's any question at all about what indicate the method thinks, means I think the West Virginia Supreme Court of Appeals should be the one to weigh in.
Thank you, Mr. Lynn. Thank you both for your excellent arguments here today. The case has been submitted. We would typically come down from the bench and greet you personally. Obviously, we cannot do that here today, but we very much appreciate your being here and helping us to do this work that we're trying to do in very challenging circumstances. So thank you for bearing with us. The court will stand in recess, and we'll call our final case here after we get everybody on board. Court stands in recess.
This honorable court takes a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, still morning here, so good morning, everybody. We're ready
Good morning,
to
Your
hear
Honors.
Good morning. Ready to hear argument in our final case this morning, Ethiopis versus Barr. And Mr. Baluarte, whenever you're ready, sir.
Thank you, Your Honors, and may it please the Court. My name is David Baluarte, and I represent Milian Ethiopis in this petition for review. In the seminal citizenship case Trott v. Dulles, former Chief Justice Earl Warren of the U.S. Supreme Court described nationality as nothing less than the right to have rights. He went on to characterize the absence of nationality, known as statelessness, as a status abhorred by the civilized world. And in recognizing the centrality of the right to nationality, Chief Justice Warren went on to describe denationalization as a punishment more primitive than torture. In his 2018 motion to reopen to the Board of Immigration Appeals, Milian Ethiopis provided evidence that Ethiopia had discriminatorily denationalized him and left him stateless in 2011. He argued that this was new and previously unavailable evidence of a change. Yes, Your Honor.
What about the fact that the Ethiopian government confiscated his passport in 2001? Would that
Your
not
Honor,
have constituted denationalization, and how does that impact your argument?
It would not constitute denationalization, Your Honor. The difference in refusing to issue Milian a passport while he was still in Ethiopia was a security measure to make sure he did not travel. That's different than denying his passport when he is outside of the country of nationality, as that effectively revokes his right to return to his country of nationality. Moreover, in the 2011 incident in the Ethiopian embassy, the consular official said that it was denying the passport because he was Eritrean and not Ethiopian. That exchange did not take place with the original passport denial, Your Honor. Milian argued to the Board of Immigration Appeals that he had presented previously unavailable evidence that Ethiopia discriminatorily denationalized him in 2011, and that was a change in circumstances. Yes, Your Honor.
I'm sorry. Can I ask you a question about just the timing on this, which is always confusing to me? So if the denationalization happened in 2011, or at least that's the best evidence at the embassy, that evidence was unavailable in 2003 at the IJ hearing, but it was available for the first motion to reopen, right?
So some of that evidence was available. The UNHCR statelessness determination was new evidence.
Right. But the fact of denationalization happened before the first motion to reopen, and then on your own account, and it's important to your argument, it wasn't raised in that first motion, and it wasn't passed on by the BIA. But that's okay to, that's not a problem. You're allowed to file successive motions to reopen based on evidence that would have been available for the first one?
Your Honor, indeed we are. The plain language of the relevant regulation, 8 CFR 1003.2C32, clearly provides that the inquiry into changed circumstances for purposes of reopening an asylum claim should always compare the new evidence to the circumstances at the time of the immigration court hearing. Yes, Your Honor.
But aren't the changed circumstances that it's talking about changed country conditions, not changed claims?
Your Honor.
This is what I think you're trying to do here, is to change the claim.
Your Honor, the Milian's discriminatory denationalization and his resulting statelessness do constitute a change in circumstances in Ethiopia. It was a sovereign decision by Ethiopia to strip his nationality, and in so doing, it removed Milian from the citizenry of Ethiopia.
But as Judge Harris pointed out, that was available before.
Not at the time of his 2003 hearing, Your Honor. At the time of his 2003 hearing, There was no claim of denationalization and no claim of statelessness.
Right. He could not have claimed it, or he didn't claim it.
He did not and could not have claimed it in 2003.
And he couldn't claim it in 2003 because it hadn't occurred yet.
That is absolutely right, Your Honor.
And in 2011, in the motion to reopen in 2011, he could have, but did not claim it.
That's correct, Your Honor. In 2011, his counsel at the time referred to a change in the law, pointing to the Third Circuit and the Seventh Circuit that had found discriminatory denationalization does constitute a basis for asylum. But at the time, he simply asked as a sua sponte motion to reopen for the board to exercise its discretion to reopen. That's different than the case before this court today.
Right. So go ahead.
Judge Thacker?
Yes, Judge Diaz.
No, you go ahead, Judge Diaz.
Just sort of following up on Judge Harris's question, which is what has concerned me about this case, you affirmatively asserted that the regulations seem to contemplate a petitioner being able to sort of trot out claims piecemeal. That is, even if he or she is aware of a particular basis for granting relief, as it appears you concede the denationalization claim seemed to have reared its head in 2011, right before the first motion to reopen. You seem to be saying that it doesn't matter. A petitioner can simply, if he fails this one time, just file another motion to reopen alleging a different claim, even if he or she understood and had all the evidence available and could have litigated that issue in the first motion to reopen. That seems a little strange. I mean, in civil litigation, for example, if you do that, you're collaterally stopped from raising claims that you either could or should have brought in earlier litigation. What is it about the immigration context that makes it different?
Your Honor, for starters, the regulation that I cited earlier is the Department of Justice's interpretation of its statutory authority to reopen asylum claims. And so it's significant that the Department of Justice has interpreted its reopening authority to have it focus on the underlying hearing as the point for comparing the circumstances. Moreover, the BIA has consistently found this to be the case in its own published decisions. In particular, in matter of SYG, which Milian relied on in his brief, that case involved Xu Young Guo's third motion to reopen, and it was on remand from the Second Circuit. And in matter of SYG, the BIA did not look at the evidence provided in the first and second motions to reopen. Rather, the BIA focused on the country conditions at the time of the hearing. This is how the regulation has been routinely applied.
But are you saying that in that case, the petitioner could have brought the claim in those earlier motions to reopen, but chose not to and instead filed a third motion to reopen, and the BIA said that was okay?
That is absolutely right, Your Honor. That case involved a family planning claim by a Chinese national, and that individual had brought a claim twice before in motions to reopen that by having children in violation of the one-child policy in China, that they had violated family planning laws in China. And with each motion to reopen, that petitioner provided additional evidence of the circumstances in China that would have validated the asylum claim. Now, importantly, in matter of SYG, the BIA focused on the new evidence provided and compared it to the evidence at the hearing. That is the appropriate comparison for a motion to reopen. Your Honor,
and in fact, at the hearing, as I recall, at least of the findings that the judge made, the immigration judge found that he, in fact, was a national and citizen of Ethiopia, right? So there was no finding or no concern about denationalization back then.
That's correct, Your Honor. The immigration judge found that Milian was a citizen and national of Ethiopia. The immigration judge further found that Milian did not fear expulsion from Ethiopia because he was only half Eritrean. His mother is a Oromo, which is another persecuted minority in Ethiopia, and the immigration judge found that significant. Moreover, in reviewing pages 720 to 920 of the administrative record, which include all of the transcripts of the hearings and the judge's oral decision, there's no mention of denationalization or any of its synonyms, expatriation, nationality, stripping. It simply was not an issue at the initial hearing. And most importantly, Milian was considered a citizen and a national at the time. Yes, Your Honor.
A question, and you can tell me how this lines up with the SYG case. So we have a case in the Fourth Circuit, the Lynn case, where we held that when there's a second motion to reopen, and this may be what you're saying too, you look at the new evidence that became available and where the claim is the same. You look at the new evidence that became available since the first motion to reopen, and you compare that to what was going on at the time of the hearing to consider whether there's been a change in country circumstances. But you don't look at evidence that's already been provided in the first motion to reopen. Is that a problem for you?
That is not a problem for me, Your Honor. That's how I believe the regulation has been written and interpreted consistently by the BIA.
But
and
then
I
it
believe
seems like
that,
but
pardon
then
me.
it seems like it would follow that what the board was supposed to look at here was what it did look at, which is the 2017 UN declaration, because that's new. That was not available in 2011. So they should look at that, but they shouldn't go back and look at the things that happened before 2011?
Your Honor, I'm sorry. I believe that the board had to consider the new evidence as compared to the evidence provided in 2003. I recognize that there is some overlap between Milian's first motion to reopen and his second motion to reopen. I also think that there are important differences, but I think most important is that the regulation and the BIA's interpretation require the comparison of the new evidence provided with this, the evidence provided with the second motion to reopen and the hearing. I'd like to dig in a little bit to the UNHCR statelessness determination that Your Honor just mentioned, because I think that one of the key abuses of discretion committed by the BIA here was to characterize that statelessness determination as a change in personal circumstances. The BIA abused its discretion when it misapplied its own precedent on changed circumstances and erroneously found that Milian's statelessness determination was a change in personal circumstances. This circuit has held in Massis v. Mukasey that the BIA abuses its discretion when it makes a decision contrary to the law. Under matter of CWL, relied upon by the BIA in this case, a change in personal circumstances does not qualify as a change in circumstances in the country of nationality for purposes of reopening an asylum case. That rule of law, however, emerged from a very specific set of facts that I actually referred to before in matter of SYG, and that is a Chinese national having children in excess of the purported one-child policy in China. U.S. Circuit Courts of Appeal have agreed with the BIA's distinction between changed personal circumstances and changed circumstances in the country of nationality, but have emphasized that this should be limited to self-induced changes. Indeed, the Third Circuit in Mohammed Saud Khan found that a key aspect of a change in personal circumstances is that the applicant chooses to make the change. Similarly, yes, Your Honor.
So, and this, I find this case very confusing, and I appreciate all the help in clarifying it. Just procedurally, it's so messy. And if what I understood the BIA to be saying here was, look, the only thing we're looking at is new evidence since 2011. So we're not going to look at what happened at the embassy, at the denationalization itself. The only thing that's properly in front of us is this declaration of statelessness, and that by itself, if you take that by itself doesn't change anything about the world. That's just your client on his own initiative went and got this declaration of a thing that was already true back in 2011. And if you look at it that way, if you sort of separate it from the denationalization itself, and this is just a petitioner going out and getting a declaration, then it is more like a change in personal circumstances, isn't it? I mean, you think they should have been looking at the denationalization itself from 2011. But if they weren't looking at that, if you were just looking at this declaration in isolation, by itself, it wouldn't have changed country conditions, would it?
Well, Your Honor, I think that we offered the statelessness determination as evidence that Milian was in fact stateless.
Right.
And that is an important change in circumstances. In fact, it's the crux of our argument for why Milian qualifies for reopening.
The statelessness itself, not the declaration.
Absolutely.
Right.
But
But if
the evidence of his statelessness was key. And in finding that it was a change in personal circumstances, the BIA committed a legal error because it misunderstood the nature of the denationalization and the statelessness that resulted. The denationalization was completely within the power of Ethiopia. It was a sovereign decision to discriminatorily make the pronouncement that Milian was Eritrean, not Ethiopian. And in so doing, it removed Milian from the Ethiopian citizenry, and that is a change in circumstances in the country of nationality. Yes, Your Honor.
And I'm with Judge Harris because this is just really confusing, but that occurred back in 2011, right?
Yes, Your Honor.
All this does is sort of bolster the fact of his statelessness, which occurred back in 2011. And if Judge Harris is correct that the BIA wasn't required to consider that old evidence, but simply focus on the new evidence, why couldn't they conclude that there's nothing new here? We've got a petitioner who is stateless now. He was stateless back in 2011. We denied that request for relief back then. I don't think you were involved, but the case made its way up through our court, and we affirmed, and rightly or wrongly. But why are we litigating the same claim again?
Your Honor, I see that my time has elapsed. May I answer the question before I conclude?
I hope you would.
Thank you, Your Honor. So importantly, Your Honor, what happened in 2000 in the first motion to reopen was very different than the claim that we're advancing right now. The original motion to reopen simply stated that Milian had been denied his passport, denationalized, and that therefore, as an act of discretion, the board should reopen. It was never considered whether the discriminatory denationalization and the resulting statelessness constituted a change in circumstances in the country of nationality. The board was under the...
Mr. Baluarte, but who had the obligation to frame the claim in that way? You say it was being framed as the BIA being asked to exercise its discretion, but that was at the request of the petitioner, right? The petitioner could have made the claim that you're making now back then and framed it that way, but he didn't. So then why is he now allowed to now reframe the claim as you would like us to do here today?
Your Honor, because the evidence of statelessness is now clear. The evidence of statelessness relates not only to Ethiopia's denial to let Milian exercise his right of return to Ethiopia, but also the analysis of his right to Eritrean nationality in Eritrea. And that's what the UNHCR did in performing a statelessness determination. It declared that Milian was not a national of any country under the operation of its laws, and therefore an internationally protected person. Yes, Your Honor.
But did you need that declaration to make that claim in 2011 of denationalization? I thought you had, it seems to me that the record evidence was sufficient to pursue the claim back then, given what the Ethiopian government had done to the petitioner back in 2011.
I think importantly, Your Honor, the claim was not pursued. And I think that has at least in part to do with the fact that the situation was not clear at the time that Milian was stateless, as it is abundantly clear now. And importantly, Your Honor, I want to reemphasize that the relevant comparison is the evidence provided, the psychological evaluation that shows Million's personal suffering from his stateless status and the UNHCR's determination that he was in fact stateless. That is what the board was under the obligation to consider with the situation in 2003, and in failing to do so, it abused its discretion. Your Honor, may I just conclude briefly?
Go ahead.
If this court concludes that the BIA's various errors prevented the BIA from meaningfully addressing Million's primary argument for reopening, then the appropriate course is to remand to the BIA to address this argument in the first instance. If the court finds legal error that the BIA misapplied its law on changed personal circumstances, this court may substitute its legal judgment for that of the BIA. And in that case, this court should find that Million did demonstrate changed circumstances in Ethiopia under 8 CFR 1003.2C32, and it should remand to the BIA with an order to reopen and remand to the immigration judge for taking of new evidence. Thank you, Your Honors.
Thank you. Mr. Hardy, we'll hear from you.
All right. Thank you, Judge Diaz. Good morning, Dean Boluarte, and may it please the court, Joseph Hardy for the Attorney General. I will venture to unpack the confusion in this case for you all. First of all, let me start off with what's not before the court, if anything. And petitioner concedes in his reply brief on page 14 that as far as prima facie eligibility for asylum and withholding of removal and for protection under the CAT, he's not challenging the board's decision to the extent that it says that the state of emergency declaration in 2017 occurred because there was the 2018 rescission of that. So that's not before the court. And while he is challenging the board's rejection of the citizenship issue or the denationalization issue, he appears to misunderstand what the board did here. The board did not hold that the 2017 UN document, that it could not establish his prima facie eligibility for it. The board only says that that document by itself constituted a change in his personal circumstances, not a change in the country of removal. And so the board's decision was correct in that regard. And I would first point out, and I don't want to just rehash the brief. So actually, as far as that 2017 document, that's the thing that he is saying is a change as far as his current motion. And the UN has no relation. For one, the UN Regional Office for the United Nations High Commission on Refugees is here in Washington, D.C. It's not in Ethiopia, so it's not a change in country conditions. Also, as he says in his motion to reopen, the United Nations is an independent body. It's not related to the Ethiopian government. I mean, you could say that, or you would say that the embassy situation in 2011, obviously that is a sovereign Ethiopian territory. So that potentially could have been a change in country conditions. The problem with that is that he is just using that 2017 UN document. He doesn't directly challenge the board's determination that it's a change in his personal circumstances. He's using that as a red herring or as a Trojan horse as a way to be able to get this court to take a second look at that 2011 interaction with the Ethiopian embassy. And the court has already ruled on this document. I know petitioner says that the board did not rule on it and that the court in 2013 did not rule on it, but petitioner specifically raised that document in his 2011 motion, and the board rejected it. And he's saying that the nationalization, Judge Harris, yes.
Let me ask you something. Just assume for a minute that I disagree with you that the BIA passed in its denial of the first motion to reopen. Just assume for a minute that I don't actually think the denationalization issue was squarely presented as a changed country condition, and I don't think the BIA passed on that either.
Okay.
But I think it could have been raised, and the BIA could have been given an opportunity to pass on it, and it wasn't. If it wasn't passed on, but it could have been raised and passed on, what happens then? Do you see what I'm saying?
So, yes, I do. And
Okay.
there's a point in the brief where I point out, and I believe, I don't remember if it's Judge Thacker or Judge Diaz said earlier, the regulation and the statute for motions to reopen, it doesn't care about what your claim is in 2003 versus 2018 when he files the motion. They specifically want to see a change in country conditions. So the fact that it wasn't, or that you may view it that the board did not pass, or that he didn't raise it, or that the board didn't pass on it in 2011, that's irrelevant. The evidence was there at the time, and so the reason why I bring up saying that that was raised in the 2011 thing, and if I may, looking at the affidavit that was attached to that first motion, and paragraph 6, that's on page 230. He specifically says, I cannot, this is the alien's affidavit that was attached to that motion. I cannot go to Ethiopia because I would face severe problems there. My Ethiopian citizenship was taken away from me because of my Eritrean ethnicity. The Ethiopian government still, yes.
I'm sorry, I just want to try to save you some time. I agree that there are allusions in that brief to denationalization, but it's not presented. The argument is not there's been a change of country circumstances based on my denationalization, and the BIA appropriately doesn't address that argument. It says that to the extent he's relying on changed circumstances at all, he can't show it because the general treatment of ethnic Eritreans has not changed. And it doesn't really address what impact, if any, his individual denationalization might have. So just assume for a minute, as I understand the petitioner's claim, he's saying, look, the changed circumstance I am pointing to is my individual denationalization. And the BIA in this proceeding has never considered whether that could count as a change in country circumstances. And then he concedes, I could have raised this in 2011, but I didn't. But he looks at the regulation, which says, I didn't have to raise it then. What the regulation requires is that I'm relying on evidence that's material and was not available and could not have been presented at the previous hearing. And everybody agrees that means the IJ hearing in 2003. So what's the problem? I have a claim. It's never been, it is different than it was in 2003, and it's never been addressed by the BIA. Why can't I bring it in a second motion to reopen? Why can't
because excuse me, as Judge Diaz says, in immigration law, he is collaterally stopped from bringing something that it is the government's position that he did raise it. And I think the part that I did not get to as far as that, he says that it does not recognize me as its citizen as confirmed by the actions of the embassy in Washington, D.C. And I think you have to unpack that by looking at the board's decision. I know the language that you just read, but the board is addressing that to the extent it says in that first decision. In fact, the 2010 Department of State Human Rights Report for Ethiopia states that in October, the Ethiopian government announced a new policy that allows exiled Eritreans living in Ethiopia to become legal permanent residents of Ethiopia with full entitlement to public service. And they point out that somewhere in this decision, they point out that the mother and the siblings are still residing there, notwithstanding the fact that they are not, or apparently are not, Ethiopian citizens. So the board does get to the citizenship issue, and it recognizes that his claim that he has been denationalized.
Okay, so your answer to me is, my concern is purely hypothetical. In this case, the BIA did reject a claim that an individual denationalization can constitute a change in country circumstances. But I guess I would like you to answer my hypothetical question. If I thought the BIA had not squarely addressed and rejected that claim, is there any reason why the petitioner can't bring it now after he has already filed, in a second motion to reopen?
And so the reason why he could not...
Is there any bar on successive motions to reopen in these regulations? Because I actually don't see one, which surprises me.
yes, there absolutely is, and I think the issue is that Dean Balaarte has you looking at the regs and not the statute itself. If you look at 8 U.S.C., I don't know if you have this statute, but I'll say it out loud. 8 U.S.C. section 1252 D2, right? And I'll read it for the record. A court may review a final order of removal only if another court has not decided the validity of the order, unless the reviewing court finds that the petition presents grounds that could not have been presented in the prior judicial proceeding, or that the remedy, you don't really need that last part, or that the remedy provided by the prior proceeding was inadequate or ineffective to test the validity of the order. So it's a collateral estoppel rule. It's a jurisdictional rule. It's written directly into the statute. That prevents you from revisiting your, and Judge Diaz, I do believe you are on that 2013 panel that decided or that affirmed the board's decision on the basis that the board provided in its decision. And I believe that's in the record, but I'll just point out that that 2013 decision was 509 Federal Appendix 252. So the court basically,
Mr. Hardy,
Judge Diaz, yes, please.
If I may, I'm sorry. So, and you pointed us to the statute, but I think by its terms, it appears to be limited to courts, not the ability of a petitioner to relitigate claims within the BIA. Am I missing something there?
Yeah, and so, and then there's also, I believe, 8 U.S.C. is it 1158, maybe A2D? It prevents successive asylum applications.
Well, I don't have it in front of me, but we'll look at it.
Okay. And if I have that site wrong, I'm sorry. I'm just saying it off the top of my head.
Let me just follow up. So you recited the affidavit, which did seem to place the issue of denationalization squarely before the BIA in 2011. Now, it may be that the BIA was made an error of law in not addressing that issue. Of course, that was an issue that could have been brought to our attention in the appeal of that order. I don't recall that it was, and if it wasn't, that would seem to fall squarely on the petitioner's shoulders, not the government's, and would at this point seem to foreclose relitigating that same issue here today. I mean, so does that make sense?
I think we're thinking the same thing. I don't know if I say yes, does it mean if I say it incorrectly? I think you know that. Yeah.
But the point I'm getting at is I am concerned, as is Judge Harris. I mean, this is an important claim, obviously. It's and counsel for the petitioner began by reciting the horrendous consequences that ensue when someone is denationalized, and we all agree that that's important. But it's also, I think, important that the processes and procedure be followed. And I've just been struggling with this case because if you, as petitioner seems to concede, the claim was ripe for adjudication back in 2011, one of two things happened. Either it was squarely presented and the BIA wrongly refused to rule on it, but then that went up to us and we affirmed that ruling, which appears to suggest that the claim is now barred as a result of res judicata, or as Judge Harris indicated, the claim was never fairly presented back in 2011, and therefore the BIA had no occasion to rule on it. And then that begs the question as to whether or not under these regs, the petitioner is then free to file another motion to reopen based on his alleged denationalization. So that's the issue that we're struggling with here.
So if I may, and so petitioner is correct. The reg itself and the statute, it goes to whether there was a change in country conditions. Again, I can't emphasize the country conditions part enough since the June 2003 hearing. And so, I mean, if I may go back to that, I know while counsel now wants to say that evidence wasn't in the record at the time, or I believe the argument is that in 2003, he says they just didn't give him a passport because they didn't want him to leave. His client seems to say otherwise. His client specifically says, if I may, and I can just go backwards in the record, but, and on paragraph 29, which is page 50 of the record. That's the declaration that he submitted with this one. He's talking about realizing I was stateless. And paragraph 29, he says, first I thought back to the confiscation of my passport in Ethiopia when I sought an exit permit after my detention in 2001. The government left me without any identification document. And there's all these instances in the record. If you go back and look at the declaration that he submitted with the 2011 motion, and excuse me, he said, I think I had read that a little while ago, he specifically says that the Ethiopian government still does not recognize me as its citizen as confirmed by the actions of the embassy in Washington, D.C. So petitioner himself recognized that back in 2001, the Ethiopian government didn't recognize him. What happened in 2011 is just a carry-on of what the Ethiopian government had already been doing in 2001. And if you look at
because you're saying, yeah, because you're saying that even in 2003, he characterized himself as stateless as a result of what happened with the passport in 2001.
That is correct. So if you look at page, I'm just trying to give you sites to help down the road. He says that he doesn't say that he didn't get it because they were trying to keep him from leaving the country. He says on page, let's see, 844, that they took it and they said something about because he was Eritrean. And then you look on page 850, he says the same thing again. But the second time, by using the Kabeli identification card, I went and asked them again, but they refused again because of my ethnic group and a lot of things. But they didn't tell me as why they denied me at that time. And then in his declaration, he specifically says it was arbitrarily confiscated. That's on page 935, paragraph 16. He says the same on 937, paragraph 21. And then there's a supplemental declaration on page 942, paragraph 13. He's saying that's all, not because they were trying to keep him from leaving. He recognized, I think the most direct citation for that would be the affidavit and on that's related to the Judge Harris. Yes, please.
I am so sorry. Judge Diaz, may I ask for just 1 minute? It's literally raining inside my office, and I just want to put a pot or something under the
Absolutely,
leaf.
yeah.
Well, thank you. I really apologize. It's also making a huge racket, so I can't hear anything.
I think that's a first for us.
Nothing but the best.
You need to, it might help if you paid your rent.
Next time.
Go ahead, Mr. Hardy.
That's pretty much how I feel about my virtual connection that our good DOJ has given me. So I know how you feel here. And yes, so now
I think you were saying that continues in his 2011 claim in his affidavit there, where at JA 229 he twice talks about how the embassy had told him he's not considered Ethiopian.
In Ethiopia, because of his Eritrean ethnicity, he said nothing about, well, we're trying to keep you here in the country, as petitioner is attempting to claim now. And so the point of that all is to say that this is not a change in country conditions. He had been denationalized at least from that 2001 when they confiscated the passport, and he went back a second time, just like he tried to do in 2011 to get his passport from the embassy. And each time they both told him, you can't get this passport because you are Eritrean. I guess through his father. His mother is ethnic Oromo. But if you look at again, if you look at the IJ's decision in 2003, yes, the main part of his claim back in 2003 was that they had taken like everything away as related to his father, and then at some point, I think in 2001, he went to complain about about how his father had been treated back in '98. And he was thrown in jail. When he got out, his mother told him, "You should leave the country." He tried to go renew his passport. They said, "Oh, you can't get this passport because of your Eritrean ethnicity." These facts were already in the record, regardless of of how petitioner at the time construed his claim. And so the statute 8 U.S.C. 1229A C7, I believe 1 or 2, I'm sorry. It specifically, and the regulation, they specifically are concerned with what was the evidence at the time versus what is the evidence now. And if you look, and the other thing is simply the fact that petitioner went to the embassy in 2011, it doesn't mean that that evidence was previously unavailable before. If you look at the regulation, the language specifically says, a motion to reopen, Judge Harris?
Yeah.
A motion to reopen proceedings shall not be granted unless it appears to the board that evidence sought to be offered is material and was not available. This is the key language here, and could not have been discovered or presented at the former hearing. So petitioner hasn't presented any evidence that says he couldn't have gone to the Ethiopian embassy in Washington, D.C., and somewhere around 2003 or earlier, and have been told the same thing, that you can't get a passport because you are of Eritrean descent. And so the last thing that was in the record, and I see the time is ticking down, is the fact that the fact that the 2017 document was a change in his personal circumstances, and the fact that both documents, even if you consider the 2011 one, was not a material change, those affect the board's decision to the effect that it also says that he wouldn't be able to establish changes as far as protection under the CAT. But the board also goes on to point out that you can't establish prima facie eligibility for those because you didn't establish, one, that the government would learn of that 2017 document, much less that the government would have any interest in torturing you because of it. And if you look at, and I see the time has passed, if you look at the petitioner's brief between pages 27 and 29, that's the only area where he talks about the denial of the motion as it relates to CAT. And nowhere in there does he discuss any evidence in the record that would suggest that the Ethiopian government would learn of what's happened here as far as that 2017 document, or that the government would be interested in torturing him, even assuming that denationalization itself could be considered torture. I would be the government's position that it couldn't be. But unless there are any questions, I will conclude.
All right, thank you very much, Mr. Hardy.
All right, thank you.
Mr. Baluarte, you've got some time for rebuttal.
Excellent, Your Honor. I'd like to make 3 points in rebuttal. The first was my opposing counsel cited the statute as support for the idea that this court may consider the evidence in the first motion to reopen. However, that is not how the Department of Justice has interpreted that statute. The Department of Justice's interpretation of that statute is found in the regulations that govern motions to reopen asylum claims, and that's 1003 C32. And that clearly refers to the hearing. Now, I believe my opposing counsel on some level recognizes that, and so he goes on to argue that Milian was actually stateless in the 2003 hearing. But there simply is not adequate evidence to support that. In fact, on balance, all of the evidence suggests the contrary. The immigration judge had to determine Milian's nationality. It's an immigration hearing, and more importantly, it was an asylum hearing. And so if Milian was indeed stateless at the time, a different substantive standard applies to his asylum application. So the IJ's factual finding that Milian was a citizen and national in 2003 had legal significance. Moreover, Milian described the incident of being denied a passport and provided the explanation perhaps they did that because of his ethnicity. Now, Milian is a member of two marginalized and oppressed ethnic groups, Eritrean and Oromo. And both at the time that Milian was seeking his passport, both were persecuted because they were believed by Ethiopia to present a national security risk. If Ethiopia at the time had believed Milian to be stateless, it would have forcibly expelled him to Eritrea the same way it had done with 75,000 other ethnic Eritreans of Ethiopian nationality. But that is not what Ethiopia did. Ethiopia decided to not give him a travel document so that he couldn't leave the country, and then it proceeded to persecute him in country. That is absolutely different than the denationalization claim and the resulting statelessness that he makes in 2011. The final point that I want to make, and this goes to Judge Diaz's question to my opposing counsel, this claim was absolutely not before the court in the last petition for review. The claim of denationalization that was originally raised was submitted purely to the sua sponte discretion of the Board of Immigration Appeals. It was jurisdictionally unable to then raise that claim here before the Fourth Circuit, and therefore this issue has never been before the court. This is the first time that the court should review this evidence, and the court should find that the BIA abused its discretion when it denied Milian's motion to reopen and remand for a new decision. Thank you, Your Honor.
Thank you, Mr. Belaarte. We appreciate both counsel's arguments here this afternoon. We would typically come down from the bench and come greet you. We can't do that, obviously, given the circumstances, but nonetheless, we want to thank you for being here and for rendering valuable assistance to the court in deciding this case, which is now under submission. Judge Harris, would you call me when you think you're ready to conference? You may have to deal with that issue.
I should call you, Judge?
Yeah, just let me know when you're ready.
Okay, yeah.
Yeah.
Thank you very much. I apologize. I'll make some phone calls and then get right back to you.
That'd be fine. All right, the court, I'd ask the clerk to adjourn the court.
Thank you.
This honorable court stands adjourned. Back to the United States and this honorable court.